Good afternoon. The Committee on Consent and House Procedures will now come to order. Please call the roll.
Chair Pouchet.
Here.
Representatives Hovis. Here. Meredith. Here. Buckeye Courtway. Here. Evans. Here. Faulkner. Here. Engel. Here. Owen. Here. Thompson. Here.
First off, thank you all for being here. I appreciate everybody's interest in this as we get started with the new legislation session. I would ask how many people are here to witness, just a show of hands real quick. So testimony? A few? Okay. Shouldn't be a problem then. Just ask that everyone testifying try and be pertinent and, as brief as possible. I'm not going to set time limits, at least not starting out, but we are under time constraints to get this show going. But as right now, and if we do start getting repetitive, I may ask you to conclude. But other than that, we will now hear our House Resolution 11, sponsored by Representative Patterson. Mr. Patterson, you may begin when you're ready.
Thank you, Mr. Chair, members of the committee. Very pleased to be here. State Representative John Patterson, District 30. Very pleased to be able to present H.R. 11, which are the rules for our body for this session. And I will begin just by going over the points that I think are different than what we've had in the past, and then we can have a discussion about some of the points. So I'll begin with Rule 21. I think that's just a clarification that just says that the majority and minority positions are proportional to the elected membership. I don't think that's too controversial. Rules 23 and 24, they do change some of the committees and some of the committee names, and they're all listed there. Rule 24 on page 13 just says that appropriations subcommittees have the ability to have bills referred to them, just clarifies that. Rule 24, Section 4 states that the Speaker will designate all the subcommittees. In the past, I think it's been with the advice and consent of the Speaker, so essentially nothing really changes there. Rule 24, Section 28 changes the current practice of bills being automatically referred to a Rules Committee. There will be 3 Rules Committees now based on this proposal, and that they will be assigned by the Speaker and referred to the committee by the Speaker. Rule 24, I'm not sure that that's 24, Section 28. I'm not sure this is as significant, but a committee on rules can already place a limitation on the time of debate. This will allow a member to request that. Rule 25, the Speaker will designate the subcommittees, and the minority floor leader will designate the minority members on that committee. Rule 25, Section 2, on page 31, appropriations subcommittees can have bills referred to them. Rule 26 on page 33, the committee chairs will report the bills out of committee at the Speaker's request. I think this was done so that we have a more streamlined process and that the committees would have to be a little bit more selective about the bills that they hear because there will be a limit on the bills that come out. Rule 26, Section 7, I don't think this is controversial. All the committee chairs must attend training. Rule 27, if a sponsor can't attend the hearing, they can have someone present the bill in their stead, another representative. Rule 27 just changes some of the rules regarding remote testimony and says that they can do it under special circumstances. Rule 30 is a change and requires that committee chairs can require that amendments be distributed 24 hours in advance, which I think, generally speaking, is a good practice. Rule 31 is just simplification regarding when committees can hold hearings. Rule 49 just clarifies that an amendment sponsor may not substitute their own amendment. Rule 49, Section 2 on page 51 does limit the number of amendments to the amendments per amendment, and this, under this proposal, would be limited to 3. Rule 50, I think, is very good for the members. Should be very popular. Just states that the Speaker cannot change the handler of a bill if the sponsor objects. Rule 72 on page 63, all motions on a bill must be germane to the subject of the bill. I don't think there's anything substantive changing there. It's just a clarification. And with that, I'd be happy to answer any questions that you may have. Thank you.
Thank you, Representative Patterson. Just for clarification on Rule 30, you said the committee chair may require amendments be distributed. It's not mandatory, correct? That's up to each chair as it goes. Is that correct?
Let me just check
Sorry,
there,
Rule,
sir.
Rule 30, page 36.
Page 36. May require, yes.
May require. Right?
May require.
And then on Rule 49 there, the number of amendments to the amendment.
Would be limited to 3 under this proposal.
So making sure my math is correct. So we have 30 amendments possible and 30 amendments to the amendments possible. So that's 120 amendments we're limiting it to for each bill. Is that correct? Anyone, not just Representative Patterson, if you've looked into this?
I think my understanding of that is that it would be amendments to the amendment. So you can have as many amendments as you want.
Okay.
But then once Amendment 1 is heard, there's a limit of 3 amendments to the amendment.
So we're not limiting the number of amendments.
Correct.
Correct.
That is correct.
Just making sure. That's all I have. Anyone else on the committee? Representative Engel, sorry.
We're a little bit different. Good afternoon, Representative. How are you?
Good, thank you.
Okay, so let's go over some of these changes. First of all, can I start? Do you have any amendments that you're going to be offering?
I do believe there will be one amendment regarding some of the budget items, so that it'll state that the subcommittee will have a bill referred, but it must go back to the budget committee before it's passed. So I do think that amendment has been drawn up, and we can discuss that.
Okay. And any other amendments?
There have been some proposals out there that we're considering, and we've had some good discussions with members, but I'm not aware of any amendments that have been filed.
Okay. So I want to go over some of these changes with you, kind of in the order of importance, in my opinion. Let's talk about the specific changes to the amount of time that folks are able to speak on perfection bills, going from 15 minutes to 10.
Yes, that's page 68. So that's been changed to 10 minutes. And then the third reading has been increased to 10 minutes. So the total time for a bill really hasn't changed. But on perfection, I think we want to get more people to have a say. And so if we decrease that time, it might allow more people to speak.
Why would more people to have a say? So at the is there a reason why we have to stop debating if there are more people who want to speak? I mean, isn't that the role of the floor leader to determine that through a previous question?
Practically speaking, we have committees. We have we can't be there an infinite amount of time. There are 24 hours in a day. So practically speaking, we are limited to the amount of debate that we can have. And so if you decrease this time, you might allow more people to have a say.
So, and I do want to push back on I'm reading this, and it does say that 5 minutes on third read. In my time in the legislature, and your time as well, we came in at the same time, we've never been limited to 5 minutes during third read to speak. It's always been 10 minutes. So that's either something that the parliamentary procedure, like committee, as well as the chief clerk have overlooked for the last 4 years, or that's not correct.
It may be, but I have no reason to think that's not correct. These are the rules from the previous session.
But we've never been held to those rules.
In practice, you might be right, but I do believe this is correct.
Okay, so my consternation with going from 15 minutes to 10 is multifaceted. We are a part-time legislature where we are here for 5 months out of the year. I think most of us who've been here a while can argue that the first month we don't do a whole lot. As a member of the minority party, we don't get our bills referred to committee regularly. And when we have controversial bills heard on the floor, it's our time to be able to debate on behalf of our constituents, the same amount of constituents that every other representative in the House represents. And so I have a lot of consternation with reducing that time from 15 to 10 minutes, considering we are paid the entire year by the taxpayers of the state. And we need to have healthy, democratic, Socratic debate heard by the people. Whether we agree with it or not, we need to be able to have, and so I have a lot of consternation taking it from 15 to 10, and I'm not hearing justification on why, because you, as a majority party, you all control the length of debate. You can stop it at any point with the currently existing rules of the House through the PQ. And so why would we try to diminish and reduce the amount of debate that we're hearing on highly consequential bills?
Well, Representative, your point is well taken. We do want robust debate. Like I said earlier, if people are limited to the time they can talk, more people could speak, or we could make less use of the PQ, which is a highly privileged motion and should be used as little as possible. So those are some of the reasons, but yes, your reasons and your points that it might limit debate are well taken, and again, this is just the first draft
Okay.
of this resolution.
So that's my first piece of issue with the proposed amendments.
If I can, Representative Ingle, sorry, I didn't mean to interrupt before you go on. So looking at the rules, the current rules is the committee member, the bill handler, and the ranking committee member from the party have 10 minutes. Everyone else has 5. So that's what it's on consent.
That's on consent bills.
Yes,
That's not on,
it is 10.
so it's
So it's just a
currently
typo.
10 minutes in third read, so we're not getting additional time during third read according to our own House rules.
Good point. Thank you.
So we're only diminishing debate. And I think that, you know, we've had conversations, I've had conversations with many members over the last few days. We don't need to hear anyone's viral videos, part 2, on third read. I think we can all agree to that. But the time for changing bills, influencing the members of the body, is during the perfection vote. That's when all of the really good amendments are drafted. And I think that would also affect the ability of members on both sides of the aisle to draft amendments. It would place a lot of pressure on the amendment bar they would have less time to do that as well. And so I think that there's a lot of really creative ways that we could maybe reduce time on the back end when we're just doing an up or down vote during that third read. But perfection is where the sausage is made. So I would hate to see that part reduced. So I want to go on to, okay, let's go to Rule 72, which is on page 63. And I understand that the intent is to clarify that any amendment added to a bill would be germane to the subject of the bill.
Yes, ma'am.
And my concern remains that by it saying shall be germane to the subject of the bill, it in essence makes something germane to the subject of the bill, regardless of whether it is.
I can see where that could be interpreted like that. I have spoken with some attorneys, and they assure me that it doesn't necessarily say that. I think it might be clearer if it said must be germane. Mm-hmm. But for example, if the rule says that gentlemen shall be in a coat and tie, does that mean if I walk into the room I am in a coat and tie? I think it's a little bit of language there, and I think we could change it if required.
Okay. I just wouldn't want to set up a situation where we are in violation of our own constitution.
Where every motion is germane.
Right.
Because it shall be germane.
Correct. Okay. I want to go to the 24-hour amendment rule for committees, please. Let's see if I can find that. Thank you. Thank you. Okay. Okay. So the rule change would be the committee chair may require amendments to be distributed 24 hours in advance of a committee hearing. Were they able to do this before?
I believe so. I think it's a good practice.
Okay.
Like I said earlier, I've done it in my committees. It's just good to let people vet the amendments before they're seen in committee. I understand sometimes it's not possible, but I do think it's a best practice.
Okay. So although it says may and not shall, which I appreciate, my concern remains that I have sat on committees that have been noticed up exactly 24 hours prior to a hearing. I'm seeing witnesses in the audience who have probably also had to make quick turnarounds to get back here to Jefferson City for a hearing. That would, if a chair decided not to allow amendments, then basically that would shut down that entire process for all members of that committee. They would be unable to file any amendments. So while I appreciate the transparency and having an amendment dropped 24 hours prior and giving the members of that committee the ability to read it in advance, it also cuts back on their ability to make any pertinent changes.
I do see your point there, and perhaps that could be clarified if it said if this rule is in place, you have to give a certain amount of time for the committee hearing to be noticed up. I think that would be a reasonable thing to do.
Okay. Let's see. Let's talk about the 20 bill limit. And what is the purpose behind limiting the amount of bills that we are permitted to file?
I think a lot of it is that we have limited staff, and they do a Herculean job of getting our bills. But what we see more and more of, and as the trend has been, is that the number of bills has gone up. Mm-hmm. And I don't think the number of staff to write those bills has gone up with it. We also see, coincidentally, the number of bills that we pass has gone down. Mm-hmm. So while...
Is there a problem innately with less bills being passed?
No, there's not.
Okay.
But what we're seeing is if we're not passing as many bills, but we're filing more, at some point you have to say, well, maybe a member, there's nothing to stop a member from filing 100 bills. Mm-hmm. So if we put a limit, it might make members focus on their priorities mm-hmm. and limit the work that we give to our research staff. Because in all practicality, no one's passing 20 bills. There's not the work and the time for us to do that. So does it seem somewhat arbitrary? Perhaps. But if we set it at a number, then that'll give members some guidance on how many bills to file.
Okay. But it doesn't decrease the ability of members to request amendments on the sidebar.
No, it doesn't. There's nothing about amendments.
So, in essence, people could still file well over 20 bills through the amendment process.
That's a possibility, yes.
That wouldn't cut back on the work over there. And you can also request of House Research to draft as many pieces of legislation as you want. You just can't file them.
That's true as well.
So it wouldn't necessarily cut back on their work.
That's true, but if you're not going to file it, then perhaps you wouldn't put that workload on the drafters.
Okay. Thank you. Thank you, Mr. Chair.
Representative Owen, you have something on that subject?
I do, Mr. Chairman. Some of the thinking behind this, and I'll just give one example. I've got a number of my colleagues here that are expecting me to be filing some legislation, and I've had it at House Research for over a month. Part of it's never even been drafted. It's never been greenbacked. Here we're getting ready to start the session. We discussed the idea of maybe saying, okay, you can have so many drafted before the session starts and then the rest of them after the session starts. It's because we have limited staff and we, in a very short period of time, expect these people to prepare over 1,000 bills. It's crazy. That was some of the thought process in this, is to say, okay, let's limit it down so that people, because how many bills do we normally pass in a year? Less than 100, most likely. So, why are we getting over 1,000, introduced before the session even starts? So that was some of the thinking behind it. It wasn't there's nothing nefarious. It was just, hey, we've got to respect the amount of time that these people have to do it. Let's prioritize our bills, you know, and then as you say, I mean, there's nothing that would prevent you being on the sidebar saying, here, you know, here's my bill, turn it into an amendment. It's just more of a reaction of giving House Research the time to get our stuff to us in a timely fashion for the start of the session. Thank you, Mr. Chairman.
Representative Faulkner.
First of all, I'd like to thank leadership because a lot of blame has been going to leadership, and it was a group that met over the summer that came up with the majority of these changes. Because we have set year after year talking with other members, and these are the changes that have always been brought forward to us. And the amount of bills to file, you've got to keep in mind there's 162, 63 representatives. They got bills to file too. And so the more workload we put on research, the less time they have to work on other members' bills. And so that went into the process as well. As far as the 15 to 10-minute rule, you know, it was just a matter of trying to get more members to get up and talk. I don't know how many members told me that they stood up and they waited for 10, 15 minutes and it just kept going on, and so they gave up of wanting to voice their opinion. And so this was just a way for them to get up and to say their piece. And so I once again want to thank leadership for allowing their members to come up with rule changes, and that you take it and allow us to take it before all the members. So I appreciate that, and that's what a lot of the thought process went into these changes. Thank you.
Representative Meredith.
Thank you. So I've got a number of questions. I'll start, though, right there, since that's where we are in the conversation. Obviously, as a member of the minority party, I'm very familiar with standing at the mic for a very long time, hoping to get called on. And I consider it part of my job to stand there and wait, because that's what my constituents expect me to do. I will say it has been very frustrating to stand there for 3 hours and then be PQ'd and not be allowed to talk at all. But I will be honest, I'm not incredibly optimistic that changing this time limit is going to make that less likely. Are you, as floor leader, suggesting that you won't be using the PQ early in debates or as often if that time limit gets shortened?
No, unfortunately, we have to use that in a body with 163 people. We have to have a limited debate. What I can tell you is that the previous question motion is a privileged motion, and it would be beneficial to the body to have it used as little as possible. But we do have to use it because we have 163 members, and the nature of our rules and our body don't allow us to have unlimited debate.
Yeah, no, I do understand the use of it, and I'm not a person that tries to abolish it completely, though I would be very interested in constraining when it can be used and make sure that there was actual debate that happened first. Are you open to limits like that would say, like at least up until the last week of session when time is a completely different question, saying you can only use the PQ if there's been an hour of debate, or if both sides have had an opportunity to express views in a debate. We've experienced a lot of times where there's been as little as zero debate on a bill, literally zero, and the PQ is used. Changing the time limit's not going to change that, denying our constituents the chance to have their voices heard. Are you open to limits like that?
I don't think that's the way to go, but what I will tell you is this. I would commit to you that it is in the best interest of the body to have as few PQs as possible, but we shouldn't limit when and how many that we use. It would be a good thing if we had 100 PQs last year, that if we had 80 this year, because it means that we're building more. 8, 80, 10. It means that we're probably building more consensus and compromise. And like I said, it's a matter, I think, of showing respect to the minority party. But I can't sit here and limit.
And members of the majority party, right?
And the majority party as well. But I can't sit here and limit when and how many. I don't think that would be appropriate to do.
Okay. Well, I may still propose some options there, but I have a hard time stomaching a limit of overall debate or of a person being able to testify or to speak for 15 minutes. Would you be open, if you're really pushing the dropping to 10 minutes, would you be open to changing or making exceptions for that? Like if there's going to be an inquiry, I understand you might not want a 15-minute soliloquy from somebody filibustering. I may have been guilty of one or two. But a lot of times, especially in perfection, we have to spend our time with inquiries where we have really meaty discussions about the bill with someone else. And someone else is essentially using some of your time. And we even find ourselves in situations where we have to cut them off in answering our questions because otherwise we're going to run out of time. Dropping to 10 minutes would really limit the ability for that. Would you be open to inquiries at least, extending it to 15 minutes?
I'd be open to any suggestion that you have. Like I said, this is
I suppose consider that a suggestion. How do you feel about that suggestion?
Well, like I said, I'm not sure that we can necessarily say every inquiry gets this much. I mean, if we need to, you can always suspend the rules. But to put it in the rules...
Which takes even more time.
Right. For us to say this is what we're going to do and inquiries get this much, I mean, I'd love to hear your proposals.
Well,
but I think we have to have some flexibility there.
That would be one. Another option would be, I've heard it suggested that members could yield time to each other. So if I run out of my 10 minutes, say, but I'm having a really important inquiry and dialogue, another member would be able to stand up and say, I'll yield my 10 minutes to that representative to keep going. But it still gives you the opportunity as floor leader to intervene, or the speaker to intervene and call in someone else in the meantime, or call a PQ if you're going to call a PQ if you think people are using it to filibuster. But I really worry that when we're having a perfection debate, I already often feel like 15 minutes doesn't give enough for proper debate on some bills. Limiting it further is dangerous. You open to that change, yielding time?
I think that's a reasonable idea, and we can discuss that, because in practicality, you can do that anyway. The next person can inquire
well,
of
but
you
then
or inquire of that
you can't
person.
inquire of a different person.
Correct.
So if you're
the
in
other
an
person could.
Right. If I'm in an inquiry with someone else and want to continue that, I can't have another representative allow me to keep doing that. They could inquire of me instead, but then we can't keep that conversation going.
Correct. I think that's a very reasonable idea that
Okay.
you all could consider.
The other issue with the time limit, I need to find, what page was the time limit on, do you recall? Was that 36, 68? Thank you. Would you be open to clarifying in the rules that 10 minutes or 15 minutes applies separately to the underlying bill and to amendments or amendments to the amendment? In current practice, once we're on an amendment, there's, I believe, supposed to be another 15 minutes that you get there. But there's been some confusion around that. Last year, there was a healthy argument about it at one point. The person filing or offering the amendment may not get to talk on the amendment for 15 minutes if they talked on the underlying bill first. But then everyone else can talk on their amendment for 15 minutes, but they can't. Would you be open to clarifying that that's 15 or 10 minutes per bill or underlying amendment, or amendment to the amendment, substitute amendment, or other motion?
That sounds just like a clarification of a current practice. I'd be open to doing that.
Okay, thank you. Okay, back to the beginning of the rules. And I really will try not to belabor this, but did you say that you are fixing this situation? I was trying to find where in the rules with the appropriations committees it said that the bills would come from appropes and go to budget. You do think there's an amendment clarifying that they would go from appropes to budget and then to the floor?
I do think there's an amendment that has that language.
Okay, I was concerned about that. I appreciate it. Let's see, other changes. The rules committees, I didn't really understand why. I get having a third rules committee. I think that may not matter much. They each have a different name, right? There's rules regulatory oversight, rules legislative oversight, and rules administrative oversight. When that happened with the two rules committees that exist now, those names made some sense because committees that were related more to one than the other directed the bills to those rules committees. But under your proposal, the speaker could just send it to whichever rules committee he wants, and there's no advance notice even on where he's going to send it, right? Why is that? And then what becomes the point of the different names?
Well, I think you bring up a good point. I think there's just some of the language that we've used in the past that we're using again. I think what the thinking is that it would promote more discussion, because if you didn't know where the bill was going to go automatically, you would have to go talk with more members. And ultimately, that's what we want. You'd have to talk with different members of different rules committees because you didn't know where it's going. And that might promote more dialogue.
So more behind closed doors discussion, not more like open testimony kind of discussion.
Correct. And then you could also petition the speaker to get it to a committee that where you have worked out some of the differences with those members on that committee or that chairperson. So it empowers the member more to kind of foster their legislation and send it on a path, as opposed to it being set in place.
Yeah, so it feels to me like it might empower the speaker more to decide where it goes, but not the member. The member doesn't get to choose. The bill sponsor doesn't get to choose which rules committee it goes to. So if the bill sponsor and the speaker don't agree on the path of the bill, the speaker gets to choose which committee. And then the member has to divide their time in lobbying 3 different rules committees because they don't know where it's going to go, right?
Well, it does allow the member, just like we have in all other aspects of legislation, to have a dialogue with different members.
Well, they're allowed to do that already, aren't they?
I think that's a good thing when you talk with more people rather than less.
They're allowed to do that already. You're just making it where they can't focus their energy on getting their bill passed.
Right, and giving them the option to have it sent to a committee which they think might be more favorable to them. So I think it does empower the member.
But they don't get that choice.
Ultimately, that power lies with the speaker, just as it did before on the referral to the committee.
Yeah, except before, at least, the speaker referred it to the initial committee. But once it's on that path and that member has time to start lobbying the rules committee as well, they don't have the possibility that once it finishes committee, the speaker then diverts it to a different one and says, actually, let's put it over here. And now you have to start your work all over again.
Well, also in that situation, you'd have it where it would go to Rules Committee and not be able to move. So this does provide the member with some flexibility to get it to a different committee if it's not being moved out.
Okay. I think I might have a problem with that expansion of authority, but we can move on from that one. On page 26, this is about requesting the committee place a limitation on the time of debate. Just a clarification, that's just a request. The committee still has to vote and pass that limitation, is that right?
That's my understanding.
Okay. And so really anyone could have already requested that probably, I mean.
Yes, if you look on section C, I believe it's all written out there.
But does the person requesting have to have approval by the speaker to request it?
Under the current situation?
No, under the rule you added.
What line are you referring to?
Page 26, toward the bottom, the new language, or any member upon approval by the speaker may request the committee place a limitation.
Which line is that?
Line 687, I guess.
On the committee chair, upon approval, may request. I'm not sure what that language would do functionally that would change things.
You'd be fine with taking out upon approval by the speaker, because I don't really see.
I'd be fine with considering it.
Okay. I'm making a note. Okay, page 31. Oh, that was the approps situation. I think that you clarified that. Thank you. 34, first of all, I just want to say I appreciate the ability to substitute somebody for you if you're sick or whatever. I think that was a good change, especially for accessibility issues. I am concerned on that page about the accommodations for public testimony virtually. And it feels like we're limiting it a little bit further when I had hoped we might expand public testimony virtually. And this makes it where it's the approval of the chair and the speaker, not of the committee. And it's only if, in the event of an emergency and if special accommodations are necessary. I'm a little concerned about us finding ourselves in an ADA problem where we're not allowing somebody to come in, or maybe we allow one person to and not another, and it's an equal access problem that we have. I'm wondering if you'd be open to a broader ability for people to always testify remotely, but allowing the committee to place limitations on time or number of people that can do so, just to make sure that we're allowing more equal access and accessibility?
Like I said before, I'd be open to discussions on any rule changes. I do think it is best
Well, this is
when...
the place for it, right?
Absolutely. I do think it is best when people come to testify that they do so in person. We've only had the remote testimony rules since the COVID pandemic. I don't see the problem here with the language that says if it's an emergency or a special accommodation. That's gives some wide latitude to the chair and the speaker. So I'm not sure if functionally it would change anything because, again, the word special accommodation are in there. And if people have a disability and can't come, I think the chair and the speaker are well within their rights to accommodate that person with the current language.
Sure, I just think that they might open themselves up to a lawsuit if they do one time and don't another time. And I would prefer we not open ourselves up to lawsuits about closing access to the public and would instead just broaden access to the public. Whether you have a disability or just a work schedule or a family schedule that prevents you from traveling to Jeff City to testify, I like to think Missourians should all have the right to do so, not just with permission of the speaker and a committee chair.
Well, we might have a difference of opinion on that. I do think it is best when
I think it's best.
Constituents want to testify on a bill that they come in person. I think it's more meaningful when we see them live and hear their stories.
I agree. I just think we've also seen, in my 6 years here, it's been very obvious to me that a lot of times the folks most impacted are the ones that have day-to-day lives that they can't leave or have transportation challenges, and they can't get here, but paid lobbyists from another state can fly in and testify. And if we allowed Missourians a little more access, that wouldn't be a bad thing for democracy. Okay. Page 36, you talked a little already about the 24-hour notice and that concern. I do appreciate that there are times where it's good to have notice of amendments, not have amendments all dropped in committee specifically as a surprise. But definitely hope you will consider adjusting it so that there's not a situation where we don't have time to draft amendments.
I do. I think that's a very reasonable thing to do.
On that same front, we've had a frequent problem of early even in session, committees deciding to exec on bills the same day that they hear them, which is generally frowned upon. And we don't generally get real notice of it happening because there's just a box checked on every single notice that we might exec afterwards, which really does prevent drafting of amendments. And more importantly, it prevents drafting amendments based on public testimony. A lot of times we learn a lot in the public hearing, then we don't have an opportunity to actually draft amendments. Would you be open to a rule that actually clarifies, except maybe in the last week of session or something like that, that we are not to have exec sessions on the same day as a public hearing, except in cases of emergency?
As a general rule, I think it's best to hear the bill and exec on the bill at a later date. I do recognize that there are some times that it's best to exec on the bill on that same day, and therefore I think it is reasonable to have that flexibility. As a best practice, I don't think it should be done, but I think we have to maintain that flexibility.
You say as a general rule. I would like it to be a general rule, and that we can always make exceptions to our rules by waiving them, just like we have a one-day legislative day that we have to wait on a bill moving on the floor. At the end of session, we waive those frequently because there is an accommodation that needs to be made for something to move. Could we establish that the general rule in writing is you got to have at least a day between public hearing and exec session, knowing that we as a body can waive that if something needs to move faster?
Like I said, I'm open to all the proposals as a general rule.
Open
and
to
as
is
best
different
practice.
than would you support that? That's what I'm asking you.
I would have to think about it,
Okay.
and I have to talk with the committee chairs. But committee chairs should be hearing bills and execing after the committee has had time to consider the bill. But we do need to maintain that flexibility so that it could happen if required.
Okay, can I ask you to please have that conversation before we get to the floor with this on Wednesday? Because I think this is something that would be really valuable to add to these rules. but I don't want to hear again, I'm open to talking about that, but here we are with the rules. Fair?
I'll talk with them as best I can. And again, Representative, I do think these are good ideas, and I'm happy to consider all of them. I can't promise you that we can do these things, so I do think they're good ideas, and we can continue that discussion.
Okay. I appreciate that. Okay, moving to 38. This is about House Committee bills being having public hearings in rules upon the written request of any 5 members. Why are you taking this out?
Well, in all practicality, have we had House Committee bills recently?
I can think of 3 or 4 that I've had in my time here.
Okay, and then we're taking out the written request. I think it'd be fine if members did want to hear it in rules. I'd be open to that suggestion, and we could change that.
Okay. If we do that, would you also be open to saying that upon written request of the Rules Committee, or of 5 members, the Rules Committee would hold a public hearing on any bill in its possession, even if it's the same day as execing it? The reason I ask, House Committee bills had this rule specifically because a lot of times they didn't have a public hearing in the originating committee. They just put together a bill together and then passed it. And so in order for it to have a public hearing, the members could request, well, let's at least have the public hearing in rules. But we also have a situation where frequently at exec session of any bill in a committee, something gets added or changed in a very significant way. And that something never did have a public hearing. Rules Committee gives it an opportunity to then allow the public to testify and say, well, you know what, I testified that first time on this bill and supported this bill, but now that you changed it, I oppose it. I think it's important for us to be able to have that testimony, or at least have the option of it if members request it. Similarly, and even worse, if a bill comes over from the Senate and we amend it in committee after the public hearing, well, now it has the potential to go through both chambers without a single public hearing on that bill. So this would simply be a safeguard that says 5 members could request a public hearing in rules. Would you be open to that change as well?
I would be less open to that, and only because the rules committees are so busy to begin with. I think
Well, we're adding
having
a third.
hearings in those hearings would be somewhat difficult and unwieldy. I think the time to have that debate would be on the floor.
Well, but you
And
can't
say-
have public testify. That's my concern here is the lack of public involvement in the bill-making process. And the whole point of these hearings is to have the public and affected parties able to testify about what the impact is. If we don't ever have a public hearing, how are they supposed to do that?
Well, I think at that point, their elected representatives would have to represent them on the floor of the House. Practically speaking, with all the bills that move through rules, to add public hearings to them, I think would not be workable.
Again, it wouldn't be adding public hearings to them. It would be simply saying 5 members could request that there be one.
Correct. But if there were to have those hearings, then I think it would just gum up something that's already a very slow process. I just don't think it would be very practical.
Okay, well, I'd like to keep that conversation going. I won't belabor it right now. The limit of 20 bills, again, that was somewhat arbitrary, and I do appreciate the protecting staff. I get that problem. It's very real. I always feel bad with the number of amendments I request, even today, asking staff to draft a whole bunch of amendments to this. But I also really have a problem with an arbitrary limit on the number of bills we can file, frankly, especially for those in the minority party or those that may not be favored by leadership. A lot of times those filing of bills is the way to put on the record in the file, here are the things that we support happening in our state. I would hate to limit that or limit their ability to file something a constituent comes to them and asks them to file.
And I do understand that as well, and I do understand that one of the tasks and the powers that a member has is to file legislation on behalf of their representatives. I think that what this would do is it just makes you focus on the things that are really important, and also that nothing stops you from saying to your neighbor district, hey, I've filed so many bills already. Could you file this? It affects people in the state, affects people in both districts, and it makes you collaborate with other members.
I hear you. I would just rather there be a political consequence for that, or we're here for the people we work for, not
Absolutely.
for what the rest of us think we should limit in what we file. And we may have some reps that don't have a lot of other reps that agree with their view of how
Absolutely.
legislation ought to work.
I agree with
And they should be able to file all the bills that set forth their constituency's worldview. I would hate to limit that. I wonder if an alternative to protect staff, and staff may like or hate me for this suggestion, is allowing members and their staff to draft bills themselves. I will say I've had a frustration at times when I've thought I could draft this bill and my staff could draft this bill and we don't have to bother drafting with this. And, I'd pay my own consequences if it had major flaws. And hopefully it just wouldn't pass then. But that way we could not have to wear them down if our staff is in fact overstretched, which I think you're right, they are.
I think as a legislative body, and again, I do think that's a reasonable idea. As a legislative body, any of the laws that we propose and the bills we propose ought to have some sort of uniformity and quality to their legislation. And while you could probably write a bill pretty easily, I probably couldn't. And for me to put it out there to the public, I don't think would be in the best interest of the body. Now, what you could say is you could write the bill and have them proofread it and sign off on it. But again, that places work on them, although not as much.
It could limit the amount of work that they have to do. And again, it wouldn't necessarily have to be you as a member.
Right.
I mean, you have staff, you have a team of people.
Or I could hire someone that's familiar with
You could hire
bill
somebody
writing, yes.
outside of the building to help you write it if that's what it took.
Right.
But I just, anything instead of limiting what we can file as members, when that really is, for some of us, one of the main things we can do here to express the things that we stand for in an official way.
Absolutely. And your point's well taken. I would actually be very curious to hear whether staff would like that, because I think a great deal of their time would then be spent on correcting this bill person, and they might not appreciate it as much as we think they might.
Oh, I think you're probably right about that. And that's why I say we could bypass them entirely and file a flawed bill ourselves, if so be it. I mean, in all seriousness, and then be politically accountable for that reality. I think there is something to that. No more than 3 amendments to the amendment. So page 51. I'm not sure I understand the why behind this. Well, how does this help? Or what does this help?
The thinking there is that we want citizens, ideally you would have laws that are very clearly written, that get to the point, and that any citizen out in the state, when they look it up, can understand this is what's going on with this law, this is what the lawmakers were thinking, this is what it addresses. I think that's the best case scenario for the citizens. When you open a bill and it has 500 pages of amendment after amendment after amendment, I think it does a disservice to the people of this state who want to see what their lawmakers are doing, and they see this convoluted bill of amendments to the amendments to the amendments. We would prefer to have bills that are focused, that are reasonable, that any citizen can look at and see what were they trying to do. So I think that was the thinking there. 3, you might say, is arbitrary, but once you get to amendment after amendment after amendment, which we colloquially discuss as a Christmas tree sometimes, those are not bills that when a citizen looks at, you can see what were they doing and why were they doing it.
So first of all, aren't Christmas tree bills often enough just 100 amendments filed? I mean, not amendments to amendment. It's the same thing. They're just as amendments instead of amendments to the amendment. So how does this actually address that problem?
Well, I think the thinking is that when you get to the second degree, you lose focus of what the bill was intending to do. And so you're trying to focus the bill and have it something that an average citizen out there can look at and say, what were they doing and why were they doing it?
Yeah, I guess I don't see how this actually helps with that, because most citizens aren't going back and looking at what each amendment was and how the process was. They're looking at what the bill now looks like, and that includes all the amendments. And nothing in here is changing what's allowed on the bill and how far we've strayed perhaps from single subject. This doesn't change that. This just limits our ability to actually do the process on the floor. And I mean, amendments aren't always adding another bill or other topic. They're sometimes just changing language, rewriting a sentence here, rewriting a sentence there. And it might take more than 5 amendments, especially if they're happening on the fly, which is amendments to the amendment. It may take a little more time and work. And it feels like all this does is puts handcuffs around our ability to do that thoroughly and might actually lead to more flawed legislation because we didn't have time to amend.
Well, in all practicality, you may be right there, but we want the amendments to be more focused and to be on the subject of the bill. So that was the intent of this, just to have some more focused legislation that an average person could understand.
Okay. Well, broadly, I will have trouble, of course, supporting anything that has limits on time we talk that are more severe than we already have, on bills we file, and on amendments we offer. But I'll move on. 53, the change of the word void to moot. Why is that?
I think that's a legal term, and I will leave it up to the legal experts on the committee to sift through that.
Okay. I have some concerns about that, but we don't need to, I guess, then have that conversation ourselves. But regarding the balancing rule here, I do plan to offer a change to the balancing rule that we talked about waiving the balancing rule last year. But I want to make sure that this conversation happens in a thorough way at this stage of the process this year. When we have the crazy amount of dollars that we have right now that are one-time dollars, last year we found the balancing rule really weakened the House compared to the Senate because the Senate is not bound by it. And it really just strengthens one person in the House, and that's the budget chair. So right now the budget chair is the only one that can offer or can file an appropriation bill. And he's also the only, we're limited by a balancing rule that is tied to his original number, not the consensus revenue estimate that is the agreed upon number of the House, Senate, and governor. Would you be open to changing the balancing rule so that what we're limited to is staying balanced still, but balanced according to the CRE, not according to the arbitrary number set by the budget chair?
Well, that's the first I've heard of that point.
Well, we had a long debate on the floor on it last year, but there was a lot going on.
And it would probably be impractical to do. What I would do is I would defer to the Budget Committee on that. I'd have to discuss that with them before I would speak on that.
I happen to be on the Budget Committee, and would just stress that last year what happened was we had a lot of money set on the bottom line, like $1 billion left on the bottom line, that we were just saying we're not going to spend as a House, but not because of the CRE, not because we're trying to keep a balanced budget, just because the person that filed the original bill had said he wanted to keep $1 billion on the bottom line. We couldn't draw from that for our amendments. But then the bill went over to the Senate, and the Senate said, oh, we've got $1 billion we can spend on whatever we want. And they, in fact, spent it on a whole lot of things that happened very fast in about an hour over there. We got it the next day, and it was the deadline to pass the budget. And our choice was either we failed to pass a budget or we accept the $1 billion that they spent that we had no say over. I think that really, as far as branches and making us equal sides of the building, really weakens us, and I would ask that you consider that change as well. Want to make sure that that conversation starts now. I really appreciated the change on page 54, unless the sponsor of the bill objects, making it so that the speaker can't just designate somebody else to carry their bill against their wishes.
I think that's a member-friendly change.
Yeah, thank you. A lot of this really is strengthening the speaker, but I think that does the opposite in a very good way, and I appreciate that. Page 58, getting rid of perfecting amendments specifically for bills that have come back from conference or from the Senate. Why? Why can't we do perfecting amendments to fix technical errors?
Well, there's nothing to stop us from doing amendments. You can still amend it, it just can't be a perfecting amendment.
Well, the difference, of course, is a perfecting amendment doesn't have to then go through the whole process of conference and voting in both sides again. It's just one amendment taken up at the end that they can vote up and down.
I do, but this would ensure that it goes through that process and it's fully vetted.
Okay. So, I mean, do you agree that it's very possible that that means that this will kill bills for simple technical errors at the end if we're out of time? Or if the...
What I would think is that if the change is really necessary, that the body could work it through the process in a timely fashion.
You have more faith in the body and the other side of the building than I think most of us do, and experience says otherwise. And you understand these aren't substantive fixes.
I
They're
do.
literally...
I do.
Because I also worry that it might mean we're more likely to pass a bill rather than it die, because how many times do we hear on the last 2 days of session, if anything changes on this bill, it's going to die? We know that. I mean, that is a accepted truth. Perfecting amendments let us fix those things. But now I'm afraid either the choice will be we don't fix it and pass it flawed, or it dies. Is that your intention?
No, I think the intention is to send it back through the process and just make sure it goes through a thorough vetting.
Okay. Fair enough. I promise you I am almost done. I think I've got 2 left. 63. Oh, yeah, you already talked about this. Yeah, I like that you said, the lawyer said it doesn't necessarily say that. Well, yes. That's because the problem with that language is it can be interpreted in multiple ways. But I appreciate the intention and trying to make clearer. So I hope that that just gets fixed.
I do. I think the intent is very clear.
I think that's good. Page 65. No Senate bill shall be subject to a division of the question unless the bill has been amended. Why?
Well, on that matter, I think, and practically speaking, I've only seen this once since we've been here, but what we want with Senate bills is that when they come over, they receive the proper vetting that they deserve on the floor, and that if we're going to divide the question, that it be done in a manner that doesn't change the substance of the bill, but gives the members a time to look at the bill thoroughly.
I'm not sure I understood that. This gets rid of the division of the question entirely if the bill hasn't been amended. So essentially it's saying if the bill gets through without an amendment, it is assured an up and down vote, and the whole point of the division of the question, which is to protect individual members from having to vote for something that they think is egregious or against something that they think is absolutely essential, because they've been put in a package by the Senate, that whole point of the division of the question motion is gone.
I understand that. I'd be happy to hear any suggestions that you have that would make that section better.
I would say just take that sentence out.
I think that's a consideration we could have.
Okay. And then I would also just remind you that if you don't want a division of the question, I think you have the ability to call a PQ.
I do.
And
Yes, I
have
do.
done that plenty of times. You haven't, but those in your role have, to avoid that from happening in the first place. But I would hate to just lose the ability to have that as a protection for our members, and it feels like it just strengthens the Senate.
I understand that.
Okay. And then the last thing I think we kind of already covered, and that was the 10-minute timeline. And I will just again stress that I'd be pretty unlikely to support anything that reduces the amount of time that we can speak for our constituents, and would hope that you consider ways we can adjust that. Thank you.
Thank you.
Representative Wyndham,
Thank you, Mr. Chair, to inquire.
proceed.
First, I'd like to inquire of Representative Faulkner, if that's okay. If the gentleman will yield.
Representative Faulkner.
I do.
Good afternoon, gentlemen. How you doing?
Real good. How are you?
Good. You said a group over the summer came up with these rule change proposals. Can
Yeah,
you
we
tell
met
me?
over the summertime.
Can you tell me who was in that group?
Several of the members sitting here and a couple members that aren't.
Okay. So you don't want to divulge the name of the committee that came up with it?
It was myself, Evans, Mr. Owens, Representative Thompson, Representative Hardwick, Representative Courtway. Am I forgetting somebody? No, that's it.
Sounds like maybe somebody forgot somebody, because my point in that question is there were no Democrats in there. So
And that's why we're here now. That's
Yeah,
what
to-
we're doing the process now.
to give us rules that have already been decided upon, it sounds like.
Well, it's not decided on, it's taking it up for consideration.
Okay, thank you, gentlemen. Good morning, good afternoon, how you doing?
Good afternoon. Good to see you.
Representative Patterson. So can you name rules that give more powers to rank and file members?
I think that one that we discussed, that a bill can't be taken without the consent of the members, one. I honestly do believe the speaker choosing which rules committee it would go to is another one that is member friendly, because one of the complaints that we hear is that it's stuck in a rules committee. Well, now there's nothing stuck anywhere, that there's still some flexibility there. So those are two things I think that are member friendly.
Okay. Those are the only two things you could think of?
I think there are others, but I'd have to look through all again.
I think that at least one of those are arguable, and if we can only come up with two, I can come up with the list probably 10 times that long of new things that restrict members and put power more in the hands of the speaker. So you mentioned with the number of bills that members would be restricted to, that members, rank and file members, would have to pick. You didn't say rank and file. I'm saying rank and file. Members would have to pick their priorities, right?
I think it would encourage members to focus on their priorities.
And what reward or what benefit comes out of members then picking their priorities? Will there be any consideration upon saying, well, every member shall have one bill placed into a committee before spring break?
No, there's
Why
nothing.
why are we restricted and we don't get any benefit of being restricted, whereas we could file 100 bills and still, I think that I was going to get to this at the end, but it creates a more sneaky legislature, right? It doesn't necessarily make it where drafting has less bills to file. It makes it where, or less bills to draft. It makes it where I ask drafting for more bills on the front end just to draft, and then I file them as amendments instead of bills throughout the year. Or I try to get them on in committees in different ways. So it's kind of like creating more rules around the house. I mean, I haven't ever been a parent, but it either makes someone more likely to break a rule, or it makes folks think about ways around the rule. And it's a lot of different ways around the rule, especially when you have about 140 heads conspiring against 10.
Well, politicians always try to find the rules around things. I agree with you there. One of the points that Representative Owen brought up is that if the drafters have fewer pieces of legislation to work on, maybe they could get to your priority legislation faster. So I do think that's a reward, so to speak.
But do you understand how I just explained that they don't necessarily have less bills to work on?
I do, but
Less bills are filed, but not less bills are drafted.
well, early on in the process, if you have to focus, there might be a chance that there will be fewer bills worked on. That's all we're trying to do, is encourage members to be a bit more focused.
Okay. Do you think that drafting would be better at drafting bills in their office without much pressure, or do you think that drafting would be better trying to draft bills at the amendment bar while 160 members are trying to get something drafted all at one time?
Well, we have great drafters. I'm not sure if they have a preference where they draft their legislation. I'd be happy to talk with them, but I think they do a great job.
Okay, so we haven't asked the drafting team what they prefer yet?
Whether they prefer to do it at the amendment bar or at their office, I have not.
Okay. Or how they feel about this rule switch in general?
I haven't spoken with them about that.
Okay. And I don't think you hit on the point of what's the reward for members. Or are you thinking about a rule change where every member would get a bill of their choosing sent to a committee before a certain time, or anything of that?
Well, I think that would probably be impractical, although I don't think it's a terrible idea. If you're asking is there a tangible reward, like I get a bill automatically referred in the month of February, no. But like I said earlier, if the drafters have more time, the intent is that they could maybe get to your legislation in a more timely manner.
Okay.
But no, there is no tangible thing that you get for it.
Okay. So there are a couple things that I think kind of conflict in my mind in the rule changes. One would be virtual testimony being pretty well eliminated, in my opinion. I mean, it already wasn't a frequent thing, but now we're saying only in an emergency and at the approval of both the chair and the speaker. I mean, that just kind of adds 3 more layers of bureaucracy, I think, or at least 2. And the proxy testimony. So we're saying that we're going to give more leeway for a member to sub themselves out on a bill. I'll say that piece of commentary to myself. But we're allowing a member to sub themselves out on a bill, but a person that can't afford to make it up to Jefferson City from Carthage, they are just out of luck.
Well, Representative, I'd remind you that we do have anybody can submit testimony. We're not stopping that. Anybody from any corner of the state can submit testimony. What we're doing is saying for the testimony that you want to provide in person, come to Jeff City. If not, if you have a special accommodation, and there's no reason to think, I've not heard of any complaints where the committees weren't allowed to have testimony and the committee wanted. I think the previous rule was that the committee had to vote on it. So I just think to say that people aren't able to testify, I wouldn't agree with that completely. I think people can still submit testimony.
You haven't heard any complaints about the way we currently do virtual testimony?
I haven't. I've been the chair of a committee. We didn't really require it or need it. So
have you ever directly asked that question of a Democrat?
I have not asked the minority party about that question specifically.
Okay. And then kind of going back to what I said about these rules not necessarily making anything easier for anybody, just making people more sneaky. What you've already talked about this a couple times, but I just want you to hit on the 15 minutes down to 10 minutes again. What stops a member from being inquired of constantly? Because I've seen that eat up an hour of time with someone, whether it being substantive, in my opinion, or not, a person constantly being inquired of and taking up a person's 10 to 15 minutes that way.
Well, you asked earlier about things that are better for the rank and file, as you called it. I actually think this is a measure that would be good for members. Like I said, there's only 60 minutes every hour. There's only 24 hours in a day. We have committees we have to get to. We have events. We have other obligations. And so if someone's speaking 15 minutes in an hour, that's only 4 people can talk. If we allow it for 10, 6 people can talk. So I think that's the thinking there. With regard to lots of inquiries, I'm not sure I understand because during that time limit you can inquire or speak.
Sure. So, and this again kind of goes, it diverges a little bit, but what's to stop one person from being inquired of to the point where the other party doesn't get the chance to speak? So you're saying that you only get 6 people in an hour as opposed to 4, but what if all 6 of those people are of one party? So I don't really see how this helps anyone. It's in practice, it's the same thing. It's who the speaker calls on.
Right. So I don't think the change in the time limit really affects that. If the speaker wanted to only hear from Republicans, I don't think if you allow 6 or 4 is going to change anything.
So why are we changing the rule?
Well, like I said, you would at least get 6 people talking. And you and I both know I don't think the speaker would just call on members of one party. I think that would not be the right thing to do. And I've not seen that in my time here.
No? Not even if the only person called on in debate was the floor leader to call a PQ?
Well, I think I've seen that a time or two, but generally speaking, we allow for robust debate on the floor. I think it's a reasonable thing to ask what amount of time people get, but I think both parties are represented fairly well on the floor.
Okay, no disrespect, but I would tend to disagree with that. Thank you, Mr. Chair.
Anything further for Representative Patterson? Thank you, Representative Patterson. Is anyone here today to speak in favor of H.R. 11? Seeing none. Anyone here today to speak in opposition to H.R. 11? Please proceed. Up the front. Fill out a witness statement, please, if you haven't already. Okay, that's fine.
Hey, I'm Jessica Leveson. I actually sit in Mike Hafner's district, but I'm right on the edge of Sherry Galax, Cass County. I came here after looking over H.R. 11, concerned about the amount of power that it gives to the speaker. And I wanted to say this. We live in a representative republic, and for you and anyone to squash our voices by silencing those we elected to represent us is reprehensible. I may not be sitting in a seat as an elected representative, but I am here to represent fellow Missourians. I am not going away. All too many of you are selling your soul to the lobbyists and those filling your campaign bank accounts because you are more concerned with a large spending account for your next election instead of your concern of being representation of the people that elected you. I believe we are going to have a movement and a change. The people of this nation and of the state of Missouri are waking up, and you are grossly underestimating the people. You and your time and power is limited if you do not wake up and start representing those that elected you instead of representing your lobbyists and your own self-interest. You need to do the right thing and ensure that all people are represented. You're not God, but you will be held accountable by him one day. You have been given a great responsibility and an opportunity. You are going to use it for good or for your own selfish ambitions. House rules must give a voice to all people. You must ensure that the House rules do not silence the voices of those representing the people of our state. H.R. 11 grants more power to the Speaker, and he already has plenty. Consolidation of power is dangerous. The Speaker and Majority Leader need to ensure that the people of Missouri are heard. Anything within this document that grants more power to an individual should be removed. The power should be shared. The current Speaker could be the most impressive, upstanding man on the planet. But what this does is set a precedent that may live on past the current Speaker. Consolidation of power should never be a part of a representative republic. Our forefathers knew this was dangerous. We must have checks and balances in place. Our federal government is proof of what happens when those checks and balances that are created are not upheld. We must protect the people and their rights. I must remind you that you are not here to serve yourself, but to serve those who elected you. You are not leaders, you are servants. I ask that you do not just fall in line because of fear, but instead do what is right to ensure that the people of Missouri are all represented. I agree that there are some things within this that are good, but we need to really look closely at consolidation of power. And giving it to one human is never good, and that is not what we are. We're not a democracy. We are a representative republic. And we need to remember that. So we have to quit silencing our representatives. That's all.
Thank you for coming in today. Any questions, Whitney? Anyone else against H.R. 11? Yes, ma'am.
Hi. I want to talk about how far we've strayed in HR
Sorry,
11.
could you introduce yourself,
Oh,
please?
Lisa
And
Panett,
is
sorry.
your
Lisa-
microphone on? Like,
I think, is it
green
on?
light? Okay.
Okay. Lisa Panett, there it goes. I have researched the oldest rules from all 50 states, and ours, the oldest one that we could find was back in 1869. So it was representative of a republic. Each one of you, whether Republican or Democrat, had equal representation. That in the actual rules, it said a speaker if there should be one. So I want you to let that resonate for a minute on how little authority the speaker had. It's kind of like what we've done with our court systems now, where it's the ultimate authority and it never even was given its own building. And so when we look out as the people and we see that our republic is crumbling, you should be asking yourselves why you ran and for what purpose if you're going to give all your authority over to one person. And she's right. No matter how good, it doesn't matter how good. I don't care if I was sitting in that seat. One person should not hold all the authority, and you certainly shouldn't be handing it over to one person. In these rules that I've created from 1869, I just took it as a standard and I rewrote them. And I said, I took everything that was good, and then I said, everyone should have bills that come out of the committee. Why do I say that? Because that's the way when you read all 50 states, it never said anything about not passing. And I'm afraid that what's happened is these committees have become places for your titles. Everybody wants to be a chairman of a committee. So it's not about the people at all. I mean, is this what you want to hand off to your children and your grandchildren? Shouldn't it be about the people that you represent? Or should we just give it over to one person? And if the answer is yes, you want to give it over, then I think you need to change everything to reflect that. And we should just be electing one person. Because the lobbyists only pay one person basically now too, and they put it in the coffers. So if that's all we're going to do, quit wasting our time. Let's just elect one, and then everybody else that comes here for fraternity, sorority can just go find one. Because this is not a social club. This is where our rights exist. And so I'm coming here saying HR 11 is preposterous. And if I were you, I would be insulted. I would be so insulted that this is at the place in the game where he already has complete and utter power. And to say, oh, I thank you leadership thank you leadership for allowing us this. What? You're all kings right now. Each one of you equally. Equal kings. I don't even think you understand that. You're equal kings right now. You're only giving the power over to one person. And you're doing that willingly. And so, I mean, as one of the people that I think has probably researched more than anyone in this chamber, there might be maybe one more, I don't know. But I would say, why are you doing this? And if you're saying that you're conservative, then you should be going back to your people saying, yes, I'm doing something to get back to a conservative republic. And that isn't by giving it over to one man. And if I'm a Democrat, why wouldn't I want my voice heard in this place equally? Because everyone's constituents should be heard. And no one should be scared to take the votes on the floor. That's what you guys all came here to do. Be big girls and boys. Like, to keep the republic. And it's going away. Like, we're at the end of this. And so I say, if you want something for your children and your grandchildren, then at some point you need to say, no more of this. No to these rules. And have you even read them? I mean, that's a question. So many didn't even read them. Do you know what existed in 1869? Can you answer the question, if a speaker, if there should be one? Why does that exist? Why is it that committees were more set up like a court system that everything got out of? Why? And why are you allowing this? So obviously I'm here to oppose HR 11 and tell you there is another way, but all of you are going to have to be just like they were at the federal level and say, no, I'm going to be either Team Gates or Team McCarthy. Do you want good rules for the people or do you not? That's all.
Thank you, ma'am. Representative Engel.
Thank you, Mr. Chair, to briefly inquire.
Yes.
Thank you so much for coming to testify.
Yes.
I think public testimony is really, really important, regardless whether I agree with it or not. I wanted to ask you, because you've said that you've done a lot of research into
Yes.
our past House rules.
Yes.
Have you ever seen a time where we have restricted the ability of representatives to speak on behalf of their constituents the way that we're seeing right now?
No, I mean, the speaker was an etiquette and decorum keeper. And what does that mean? I mean, when you read these things, there were spittoons that were on the House floor. And so he kept order in that way. And if two members would stand at the same time, that he was able to say, you stood before he stood. But two other members could say, that wasn't even right. The way that we've done this, where members stand on the floor for hours and are never recognized, that is a slap in the face to our republic. A slap to the founders, to the people that have actually gone to war for this country. This is a slap.
Have we ever gone from, say, for the example I'm going to use is in this specific rule change, takes the amount that we're able to speak on a perfection bill from 15 minutes to 10 minutes. Have we ever seen a reduction in the ability of representatives to speak? Okay.
It didn't exist.
Or a limit on bills that can be filed? Have we ever seen that
No,
in the
I mean,
history
and
of the rules?
I'm talking about the oldest ones I could find. So when I talk about this, I don't know what it's morphed into up to this place. I can only speak about the purest version that I could get my hands on.
Okay. Because my worry is, as someone who's been in this building for just a few years, we tend to not get less restrictive. We tend to go more restrictive. And I say that as a Democrat. Like, it's really hard to roll back rules once they're in place.
Yes.
And so I worry that now we're at 10 minutes perfection. Is it going to be 7 in a couple of years? Is it going to go down to 5? Are we going to have public debate? Are we going to,
The way it's going, no. And I would expect that the majority members would vote for it because they want a chairmanship. This is where we are. Let's be real. Let's be real, because I can be real. Like, you guys go and you look at your constituents and you tell them one thing, but you know what's really going on here. And it's time for an honest discussion about what's really taking place.
And I would say, as a member of the minority party, I've listened to many 15-minute soliloquies and inquiries that I strongly disagreed with, but I think that's a large reason why we were elected, was to have those debates and to hear points of view that we disagree with. There's a lot that can be learned from listening to people you disagree with, and so it would be a shame to reduce that time.
Yeah.
Thank you.
Further questions?
Mr. Chairman,
Proceed, sir.
thank you for coming forward and bringing this information to us. A couple years ago, I went back and asked for all the rules we'd had since, I guess, the chamber had changed from Democratic control to Republican control. I wanted to see what had been the rules at that time to the rules that are now. And there's been changes go on about every 2 years, there's always a rule modification made. And I'd like to point out that rules do not pass laws. They don't cancel laws. They're a way for us to have decorum when we are meeting. Now, people, whether it's in sports, whether it's in politics, whether it's in life, will use rules to either benefit themselves if they want something, or to kill something they disagree with. There's all those mechanisms in place. And so when you say, you want good people, you always hope that you are electing good people. That's why the people vote on us as representatives, to represent them. But also at the same time for us to hire people to help with the decorum here, to help us work through the process so that we can get things done for the people. And so when we bring these rules forward here, I want to make sure that we are allowing us to do what you're representing that we do. But at the same time, you're right, there's many rules now. The rules from 2000, I guess was 1998, was 30, I'd have to go back and look, I don't want to misquote, but it was 30-something pages, and now we're up to, 75, 80 pages? So, it's one of those things where, and to my friend over here, he spoke earlier, he was saying about the 10-minute thing. I was going to put an amendment on there that if you were inquiring me and were really raking me over the coals, I wanted to give you 1 minute. But I knew that wouldn't be practical because we have to have fair debate. Have you gone through the current rules that we have? And I'm sorry for that long speech there, but Have you looked at the ones that currently are in agreement with what you've got, or the rules that was sent? I think I got a set of these rules sent to me. And then what is different that would need to be changed? I was just curious if there had been a comparison done.
Between the existing rules that you're under and the presented rules in HR 11?
And the ones that were sent to me, I think, from the people's rules. I got a thing on
Oh,
that.
they're just completely different. I mean, it's like you can't even find any similarity left in these rules to make a comparison. And so when you talk about the people's rules, what we have is we say everyone should have a priority 1, 2, 3, and et cetera. And how it would work is each one would go through the committee and each one would go on the floor. So no one's a chairman anymore. Like, real, you know what I'm saying? Like, you could have a chairman, but it doesn't matter anymore because everything is getting out of committee. Everything is going to the floor for a vote. And it's the way that it's meant to be. The founders did not send representatives up here to put it in the hands of one person. It didn't happen.
I would agree with you, and I want to confirm, I've had bills that have not went to the floor, okay?
Yeah.
They've been held up in rules committees. I was not on the working group or the meeting group. I was not a committee, I want to point that out, but the group that was meeting about some of these changes, because I'd even presented some that I thought would make things better. We had 2 rules committees. I felt that that was a roadblock for some legislation that we needed to get out. Having 3 rules committees and being able to send them to one or the other, it may have had less work than the others, I thought was a good thing to help us move the way that we do business forward, and also maybe giving some input to the members to be able to have these things, because we never did. At one time, there was no rules committee. So I know that anytime we're going to have rules, it's supposed to effectively help us do things. If there was something there that someone saw, I'd heard there was even a recommendation that every member should be allowed to get one bill to the floor to be voted on. I'd heard that one being thrown around. I didn't agree with that. You could be one member, file one bill, and it could be a horrible bill with something we wouldn't want, and he knew he was going to get a vote on that. We could vote it down, but also when we only pass probably 20, funding bills, basically, and then we probably pass 25 to 50 other bills. We have 163 members. Would we even be able to get important stuff spoken about and debated if we were overwhelming ourselves with that work? That was just some of my perspectives, not that it's contrary to anything, but
Sure.
how I looked at it.
Well, I mean, you would have to look over the whole proposal because what happens in that, it's limited to 30 minutes in the committee because, again, everything would go out, everything gets, a floor vote. These are hard questions. They're in there, they exist. But all I can tell you is the purity of it at the beginning, it was just there to keep decorum and order, and that's all. And look at where you are now. Look at where you are now. And all this does now is consolidate more power into the speaker's hands. It's already tons. So really, like as a person, a lay person, just back here, at this point, I don't really care that much. Because there's so much consolidation in the speaker's hands. What is a little bit more? Because you don't have any power left. I mean, and this is somebody who's talking, I talk to former speakers, and they say, I don't even know why the representatives would even show up if I wasn't the speaker.
Yeah, I disagree with that, but, I do appreciate you coming forward and bringing those perspectives and stuff like that. I don't think everyone up here sells their soul to the devil. There
I
may
don't
be
either.
some that do that.
I absolutely
but,
don't.
I know a lot of the representatives on both sides of the aisle. I think they're here for the right reasons, even when we disagree. So
Yeah, I agree. And I want to make sure that that's clear on my part too, because I believe that there's tons of good people, but there's a hopelessness that exists within the body.
I can appreciate that. Thank you.
Yeah.
Anything further for the witness? Thank you, ma'am, again for coming. Anyone else in opposition of H.R. 11? Seeing none. Oh, my bad. Pardon me. Come right up.
I'm here in opposition to it.
Sir, excuse me, could you use the microphone, please, so they can hear you at home? Thank you.
I'm sorry.
You're all right.
Thank you.
You're welcome.
As I look at this and the other things that go on around,
I'm sorry to interrupt again. We need your name for the record,
it's
please,
John.
sir. John.
Paul.
With anybody or just yourself?
Yeah.
Okay.
Oh, my dog. But,
Your dog. Okay. Fair enough. And his name? Her name?
pardon?
His or her name? Your dog?
Oh, his name's Mason.
Mason?
Oh, he got named after Perry Mason. But anyway, as I look at education, which is a big issue today, the education that I got in when I was in school, I thought was pretty decent. But I find out now that my teachers lacked a lot. Maybe they were smart, maybe they weren't, but they didn't teach me about the Declaration of Independence. What a profound document. That document said that my rights came from the creator of the universe. They didn't come from the Speaker of the House that determine what you want to have done or what anybody wants to have done. He is not to withhold my rights in any way, shape, or form. I've heard some of you talk about that everybody needed to have their voice. Our documents gave us freedom of speech, which is very, very important. If we don't have freedom of speech, what are we? So I realize you can't let everybody see, and I've come down here before, and I brought friends, and they said, I didn't realize I could go down there and speak. They don't realize that they can come here and speak and let their voice be heard, whatever party they're from, which to me is totally irrelevant. So if you're going to have someone that's going to be the speaker, that's going to control all of the legislation, I want to see him because he's going to be as close to God as I will ever get to see, and I want to see the man and have a selfie with that. It's just, I don't know how to explain it. But if you have someone that can limit the bills and limit my rights, well, you're here to protect my rights, not to take them away. Nor is the speaker here to take them away either. So I think I've got it all covered. But one thing, I did ask the Supreme Court, I approached them 3 times, and asked them if there would be anybody that could be elevated to the level of the creator of the universe, which is where our rights come from out of the Declaration of Independence. They said basically no. They couldn't produce the document. So if you have someone that's in the speaker that's at that level that can determine our rights or how a piece of legislation that's going to determine to protect my rights is going to be, he's probably been elevated to that level. And the Supreme Court says it can't happen. Any questions?
Thank you, sir. Any questions, witness? Thank you to Mason. Further in opposition. Good afternoon.
Yes, sir, Mr. Chairman. For the record, my name is Ron Calzone. I'm one of the directors of Missouri First. And I've been a volunteer citizen lobbyist, if you want to call me that, for 2.5 decades or so. I started when the Democrats selected the speaker. And I may very well be here when the Democrats are selecting the speaker again. And I say that to remind you that whatever, and I think someone pointed out that we tend to ratchet the rules up. And you've got to remember, my Republican friends, that you may not always be in control. And so think about that. I have sent emails to you all. One of them included what our list of concerns about this bill are specifically. I included that in my online testimony. I'm not going to go through them one by one. As a matter of fact, I thought for a while that Representative Meredith was working off of my notes because with just a few exceptions, he covered everything that I wanted to cover, so I don't want to be redundant. But I do want to address briefly another email that I sent you all that I hope you noticed. It was in the subject line. It said, "Not yours to give." It said, "Not yours to give." And what I was referring to is, if you take time to read that email, sent it last night, so you may not have seen it yet. I made the point that the power that you enjoy in this building is really the people's power. Article 1, Section 1 of the Constitution, which is right after we acknowledge the supreme lawgiver of the universe's power, is where the people declare that all power is vested in the people. And any power that government enjoys, including you all, is power that the people loan to you. Now, if someone loans you their pickup truck, you don't have the right to sell it to someone else. You have to use it in the fashion that they intended when they loaned it to you, and then return it back to them. And so I would suggest that whatever you do with the rules, make sure that you're not giving away your constituents' power. This isn't about your power. This is about the power that you have been made stewards over, your constituents' power. And to concentrate that power in the hands of any one person or small group of people is just anti-American. It's people throwing around the term republic a lot. Well, one of the several concepts of republic is this true representation concept. It's not your power, is my point. We watched last week what 20 brave Republicans did in D.C. And look at the concessions that those brave Republicans got out of the speaker, the incoming speaker. Crazy things like not having omnibus bills that force you to vote on things that you don't disagree with to get the things you do agree with. How about a single up or down vote on whether or not you raise the debt ceiling? Most Americans, when they read what concessions those 20 people got out of the incoming speaker, thought, are you kidding? That wasn't already that way? So most people don't know how this, well, actually, I think they do. I think most people know that in Washington, D.C., the power is vested in the hands of just a few people because the national media covers that so well. I don't think they realize it's happening here. Well, guess what the approval rating of Congress is? It's like 13 to 16%. Because they don't like the monkey business that goes on in Congress. And it doesn't matter whether there's a Republican speaker or a Democrat speaker. It's all the same thing, and people have low regard for that. So my message is the founding principles, the things that you need to understand is that you are stewards of power. You have no right to give it to other people. In order for you to represent your constituents back home, you've got to retain the power they give you. That means each one of you should have 1/163rd of the power. And yes, that means the minority party too. I do want to cover just one specific in these rules and make a suggestion. The idea of having 3 rules committees and the speaker selecting which rules committee bills go to is an insult in more than one way. As a citizen activist, I can tell you that what we will do is we will look at a bill that's been assigned to a committee, and we'll look then at where that bill is going to go to if we manage to get it out of committee, if we're opposing it, if it happens to get out of committee against our will. And we may start working that rules committee far in advance of the time that bill is referred out of committee. And the same thing will apply to a bill sponsor if he's smart, if he's working his bill. He doesn't wait until he finds out where the speaker is going to send the bill. Now, and I think that the things that Representative Patterson pointed out is well taken. You could have, sometimes there are times, if you've noticed the last few years. By the way, it wasn't always that way. There was one rules committee. And before Rod Jetton went to Washington, D.C., and he saw how the Rules Committee worked in Washington, D.C., and literally brought the concept back here, our Rules Committee didn't have the power that it does now. So that's a little institutional history for you. But if you want to distribute the workload among the 3 rules committees, I say that's fine. That's a point well taken, I think Representative Patterson pointed out. And sometimes there are bills that happen to overload one rules committee and not the other. But in order to make sure that one person, the speaker, or the chairman of a rules committee or whomever, and we're not talking about this speaker, I think that's been made clear by we're talking about speakers now and forever, then why not say that you all, this committee level, are the ones that render do pass or do not pass verdicts. The Rules Committee does what the Rules Committee was designed for, and they are allowed to hold a bill for just, say, 5 legislative days, and then it automatically goes on the calendar. And then none of these objections about having too much power in the hands of the Speaker or the Rules Committee chairs would matter. And we can spread the workload. So keep the rules like this if you want to, but add to that a requirement that Rules Committees pass the bill onto the calendar after X number of calendar days or legislative days. So there are a lot of things. If you go to mofirst.org, we also for several years have been working on recommendations for rules changes, things that we think make it fair for all members, including the minority party. mofirst.org, very top link. There's a suggestion for reforming the rules of the House. And they're not the same rules that Ms. Bennett was talking about, but they're, the idea is to distribute power. So with that, I am open to any questions you might have.
Thank you, Mr. Calzone, for coming today. Representative Wyndham.
To inquire.
Proceed.
Thank you, Mr. Chair. Good afternoon to you.
Good afternoon.
If you had to rank the Speaker of the House as a position as in the list of most powerful political folks in Missouri, where would you rank?
The current Speaker of the House and the current set of rules, he's at least the second most powerful person in the state.
Okay. And
Can I interject just one more thing?
Sure.
So with respect to what Ms. Panett was saying, our legislative history, the structure of our republic, was largely based on what the United Kingdom did. So even to this day, the Speaker of the House of Parliament, the House of Commons they call it, he is just a facilitator to make sure that every member has a say. And so, in fact, when someone becomes the Speaker of the House of Commons, he resigns his party membership. And so that's what the founders intended. And the Speaker is important to make sure we have decorum and make sure that the product flows. But his main job is to make sure that each of you is empowered, not so that each of you is empowered, but so that your constituents are empowered.
Okay. So you said arguably, right? Or did you say, what was that? You said the second.
Well, I don't know. I mean, I think you might even say the Speaker is more powerful than the governor, but so anyway.
Right. So my follow-up question was going to be, remind me how many folks how many folks are in the state representative district?
Counting the lobbyists that influence them.
Well,
So we have a huge problem, of course, when we've got people right now announcing that they're going to run for Speaker in 2 years. And everybody knows this is a hidden, a secret right out in the open. It's when you do that, you become a money magnet, and you end up buying votes to make you Speaker, and we've known that for years, and it's wrong.
Yeah.
And this is the thing I've got to interject. This whole mechanism that we're seeing profanes the whole political process. It's not just about your power even, it's about how elections run. It's about who gets elected to what, how much money by selfish interest gets injected into the process.
Yeah, so I don't disagree with anything that you just said. My point in that was that there's about 6 million people in the state of Missouri that elect the governor, and about 37,000, if you're lucky, elect a state rep. And it's arguable which one of those positions have more power.
Well,
at this point,
yeah, that's a sad statement. I think you're agreeing with me.
Yeah. Oh, yeah. It only happens a couple times a year, but I think so.
Okay. Not actually. We'll talk sometime because I've been watching you, and we agree much more than you might think.
Okay.
But the shame of it is that this, and I'm not talking about Dean Plocker. This is not about Dean Plocker because I've been on this bandwagon for numerous speakers. Okay, this is not about the current speaker.
Same here.
But generally, I would maintain that the Speaker of the House is not even representing his own constituents. His constituents didn't get him to be Speaker of the House.
Right.
You all know that. I don't need to tell you that. And it's a problem that needs to be solved. And I think it's time to man up, just like 20 Republicans manned up in Washington, D.C., and now are receiving all kind of accolades.
Thank you, Mr. Chair.
Thank you all. Due to time constraints at this time, knock the microphone over.
Mr. Chairman?
Yeah.
I think you have somebody.
Oh, sorry. Representative Buckeye-Gorrick.
To make a statement, sort of inquire.
Proceed.
Thank you. So I've heard a lot of people here and in the past few days mention what happened in Washington, D.C. last week. And I don't think it's really fair to compare the two because it's completely different. What we are doing here as a committee is looking at this document and saying it's a work in progress. Several people on both sides of the aisle says that there's going to be amendments, and the conversation here has been very, very good. There's been several ideas out here that people have communicated, and so what we do as a committee is we vote to get this out to the floor for the rest of the 163 people to be able to debate this. There's 10, 12 people here on this committee, and this is an important document, and it needs to be vetted by everyone on the floor. And when people are talking and saying how we're giving all this power to the speaker. If we vote on this document, it's not necessarily saying that we're giving this power to the speaker. It's saying we want to get it to the floor for every single one of us to be able to debate. And I almost feel like we're being downgraded for sitting here on this committee just listening to this.
Well, if I gave that impression, I apologize. But one thing to keep in mind is that this or any other piece of legislation comes out of this committee with two recommendations. It's either do pass or do not pass. It's too bad that there's not a do pass with some fixing on the floor, and maybe there's some way that could be considered. But I think the idea of a committee like this too is to make this bill the best that you can, because you are getting input that they're not going to get. Well, they will actually. Every member will be getting a lot of input, but you make this bill, that's not the bill, make the bill the best you can before you put a do pass stamp on it. And that means that you can fix, there's some good things in H.R. 11, and there's some bad things, and there's some just things in H.R. 11. But your job is to do the best you can before you put that do pass stamp on it. And I think that means you fix some of the problems that have been brought to light, make some of the improvements. I love the idea of saying that one member can be limited to debate to 10 minutes, and you can give what's the term I'm looking for? Yield your time to someone else. When you have a subject matter expert.
Mr. Calzone, I'm sorry to interrupt, but I don't think the representative was done speaking.
Okay, I'm sorry if I interrupted you.
No, it's fine. I just feel like this is, everything that we hear is very, very important, yes. But this is something where is anyone going to be offering any amendments today? Are they? Okay. Well, then maybe I'll just stop with my comments and wait till we hear those amendments. But I kind of feel like some of the comments have been a little, not necessarily yours, but have been a little derogatory to just people sitting on a committee. We were chosen to sit on a committee, and I don't think that's right either.
I think what we're asking is for you to protect the Constitution, protect your constituents' power while you're sitting on this committee and within the realm of what a committee does. And I should probably sit down so you can get to the amendments.
Thank you, Representative. Quickly. Yes.
Thank you, Mr. Chair. Can I inquire of the lady who just spoke, please?
Quickly.
Thank you. And don't want to be derogatory at all. You and I are going to disagree about a lot of things and a lot of bills, and it absolutely does not need to be personal. I understand you were on the work group. Is that right? That came up with the suggestions in the bill?
Yes, I was on the work group, but that doesn't necessarily mean we came up with all of the suggestions either.
Right. So as someone who's sitting on this committee and was not party to that work group and was not party to any of that process, was there public input? Who appointed this committee? We don't know anything about it.
It wasn't a committee. It was just a work study where some people got together and
Were you appointed by someone to do that? Or did you just self-select? Because there was some way that a work group got this document to the Speaker of the House and the floor leader of the Missouri State House of Representatives and is being proposed as our House rules. And I'm just trying to get some clarification and transparency.
I didn't see this document until it was filed.
Okay.
We had a paper that had concerns. I understood it was from both sides of the aisle. I might be mistaken, but that's how I understood it, that members have just made comments of things that they would like to see changed in the rules.
Okay.
And it doesn't necessarily mean that we all believed in everything that was on here or that everything was discussed.
Do you know where that paper is?
I mean, I don't have mine with me.
So do we know who drafted the rules that we're looking at here?
I would assume John Patterson and his staff, maybe. I'm not sure who drafted this.
Okay. Thank you, Mr. Chair. Thank you, lady.
Am I dismissed, Mr. Chair?
Yes, thank you, Mr. Cousin. Anyone here for informational purposes? Seeing none. That conclude our public hearing on H.R. 11. Now we're going to need to recess until the adjournment of session or 4:30 this afternoon, whichever is later, and we will reconvene back here again, H.R. 3. Thank you all for coming. Have a good night. Committee on Consent and House Procedure now reconvene. Please call the roll.
Chair Pichet,
Here.
Representatives Hovis. Here. Meredith. Here. Buckeye Courtway. Here. Evans. Here. Faulkner. Here. Engel. Here. Owen. Here. Thompson. Here. Wyndham.
Have quorum. We will now move into executive session. I move that H.R. 11 be voted do pass, and I have an amendment that has been distributed. It ends in .38H. We will discuss. Let me get that down. I'm not going to read the legalese unless we have to, and if you guys have questions, please we'll go back into it. But I'm just going to briefly do a summary of what was changed from the discussion 2.5 hours ago. We are keeping the 20 bill limit. That will become effective July 1 of this year. Correct? Right? July 1. On the budget, there are two changes. Appropriations, the terminology in there, the wording, it basically just put in there that it must, after appropriations hears a bill, it must go to the big budget committee, does not go right back to the speaker, so big budget will see it, and it'll get wrapped into the bigger budget. Also, the budget subcommittees, appropriation subcommittees will not be able to drop substitutes. They will only be able to deal with House bills with House amendments. That way, we don't get too wrapped around the axle with subs being on subs once it gets into the big budget committee, and that would cause headaches, apparently. We've taken out the 24-hour notice, so that is no longer there. It's been axed, change. The speaker now has a 10-day limit he has up to 10 days to refer a bill to a rules committee once it's passed out of committee. We have removed the number of amendments available, or the amendments to amendments, sorry, so that's all gone back to where it was, status quo. We've also removed the change to the time speaking, so we're back to 15 minutes. We have fixed the wording on Rule 72 for their germaneness, I believe everyone wanted. And remove the requirement wording for the 24-hour amendments to committee. I believe that was everything. Any questions on any of that? Representative Wyndham.
Thanks, Mr. Chair. Just briefly, I wanted to ask you, what was the 24-hour amendment? Where is that in this amendment?
Second. Yes, 1 second.
It's the last instruction on the first page.
Sorry.
Last instruction on the first page.
Oh, the new one.
Page 51.
1342 to 1343.
Okay.
I believe that.
Oh, that's the no amendments to amendment, or no more than 3 amendments to amendment. We're striking that part.
Correct. That is gone now.
I think you said something about 24-hour rule that you were taking out, right?
Yeah, that was taken out.
Okay, so
That was also taken out, correct.
we're just completely striking it.
Hold on. 26. 6.
Okay, that's the instruction on the amendment starts on line 29 of the amendment.
Okay, thank you.
Instruction above that is actually for that
Yeah.
as well.
Well, it just says in page, it doesn't have the page number right there.
Sorry.
The one
Damn
above
it.
it.
It's
Oh, okay,
yeah,
36.
it's down.
36.
So it'd be page 36, I believe, 944, right? Line 944? Or 954, sorry, 954. Committee chair may require amendments be distributed 24 hours. That's been deleted.
Okay, thank you.
Mm-hmm. Representative Meredith.
Comment, please.
Proceed.
First of all, I appreciate a lot of these changes. Thank you for taking the time to get them in there, and thank you to everyone that helped make that happen. One thing, the approps change to the approps subcommittees. As I'm talking to more folks about this and learning more about it, I still think that I support this change happening, but I just want to caution by the time we get to big budget, to the floor, that we've made sure to talk to the staff of approps and a few other people and make sure we understand logistically how this is going to happen. I have heard some concerns already about whether these are actually subcommittees or if they're different committees, for example, and that's not something that had occurred to me since they're called subcommittees. But I would personally like to get some clarifications on that by the time we're there on Wednesday. And so you may find that I no longer support this then, but as of right now, I do, so I appreciate that change. Just, I want to put that out there, just that I think there are some more conversations about how this works that need to be had by Wednesday. Thanks.
Representative Hovis.
Mr. Chairman, sorry.
Whoa.
Moved you up there. On the second page of your amendment here, and this is just a technical thing that I'm asking, line number 4, where we're deleting the word shall and replacing it with the word must. I thought shall was a very powerful word, but is must more powerful than shall? Maybe looking at the judge over there.
It's a legal term, and I'm going to defer to the legal experts in the room. And I believe it was requested, I believe, so that was given. So we moved it to must. Yeah. So. Yeah. That's all.
Okay. Well, I just want to make sure because I thought shall was pretty strong.
Apparently, there's differing opinions, so we're here to make everyone happy.
Yes, I did, but I thought shall was really
comment.
strong. So thank you.
Are you done, Representative Meredith?
To comment on that.
By all means.
Just to follow up, yeah, I do think that this helps with that clarity. That said, honestly, it would be clearer if we instead just worded it as it shall not be in order unless it is germane, as opposed to, which is what the old rule kind of said. And so I do think it's worth looking at that still, but I do think must works better than shall. So.
Yeah, and that was my only reason because I know there's legal definition on shall. I didn't know if we had one in the Constitution or in our rules on must. That was only a technical question.
Okay, no further discussion. I move for the adoption of House Committee Amendment 1, signify by saying aye. All those aye. All those opposed say no. All those opposed say aye. Aye. No. You have adopted. The ayes have it that you have adopted the amendment. All right. Any more amendments we'd like to be offered? Representative Wyndham.
Thank you, Mr. Chair. I have an amendment ending in .28H, and I move for its adoption.
Offer an amendment ending in .28H. Proceed.
All right. Thank you, Mr. Chair. So this amendment deletes the 20 bill limit entirely. If there is any part of the newly proposed rules that grinds my gears, excuse that, but really just gets under my skin the most is this rule that each member of the each member of the House, not legislature, has a 20 bill limit. This is coming from someone that had 31 bills last year. However, if I wanted to, I mean, this is just goes to my point of folks are gonna stretch the rules if they need to. I could have combined 6 or 7 of those bills and made them a huge higher education bill. I don't think that necessarily would have helped anyone or changed the situation at all. I had 5 or 6 public safety bills that I could have all squeezed into one bill. Then it would have been 20 bills. It would have been the same amount of work, or it probably would have been a more poorly drafted bill, being an omnibus. But I'll just end there and open myself up to any questions. Thank you, Mr. Chair.
Any questions? Representative Meredith.
Thanks. Just to add my support for the amendment, for a lot of us in this building, really on both sides of the aisle, there are only certain official actions we can take with a record that we have that authority to do for the sake of our constituents. If the speaker and the floor leader want it, we will never have a bill heard in committee. We will never be able to speak on the floor if they don't ever want to acknowledge us or call on us. But one thing we can do to represent our constituents and show them on the official record is the bills we file. And I think it's a really dangerous road to go down for us to start limiting that. And I do think the representative makes a good point that it would really only incentivize more omnibus bills, which I think a lot of the more conservative folks in this building aren't a big fan of, as opposed to more discrete true single subject bills. So I'd ask the members to vote for it.
Further discussion?
Mr. Chair, if I may, I'd like to ask for a roll call vote.
With all due respect, Rita Wenham, I'm not sure. That's fine. We can do a roll call. All right. So all those in favor of adopting, right, House Committee Amendment number 2, right? Sorry. All right, so I move that House Committee Amendment number 2 be adopted, and please call the roll.
Chair Boucher,
No.
Representative Hovis,
No.
Meredith, Evans,
By a vote of 3 aye and 7 no, you have failed to pass Amendment number 2. Any more amendments? Right. Representative Wyndham.
Thank you, Mr. Chair. I have an amendment ending in .31H. It has been distributed, and I move for its adoption.
Representative Wyndham has offered amendment ending in .31H.
Shall I proceed?
Proceed, sir.
Thank you, Mr. Chair.
Sorry, I'm slow.
No worries. No worries. I didn't just want to be that silence there. I didn't know if it was mine.
No.
All right, so this amendment would keep the 20 bill limit, but give us one bill hearing by legislative spring break. It's kind of a running joke that all the bills get referred to committee. However, that's on the last day of session. And I think that we may have some members in this body that have served in this body for as long as I, or even longer, that have never had a bill hearing, and that's sad. So this bill hearing wouldn't necessarily say that your bill gets out of committee. It doesn't say that your bill gets to the floor. It just says that since we only get 20 bill limits and we need to choose our priorities, that our priorities are actually priorities of the House that we serve in, and that we'll at least get the first step of one bill heard, which I think should be a very low floor. And with that, I close. Thank you, Mr. Chair.
Any discussion? Seeing none. All right, I now move that. Nope, wrong one. Sorry. All right, all those in favor of adopting House Committee Amendment number 3, signify by saying aye.
Aye.
No? No. The noes have it. Voice vote. Further amendments? Representative Wyndham.
Thank you, Mr. Chair. I have an amendment ending in .30H. It has been distributed, and I move for its adoption.
Representative Wyndham has offered amendment ending in .30H. You may proceed, sir.
Thank you, Mr. Chair. This amendment simply puts what I believe is a best practice that many chairs already use into a rule, and it says that no bill shall have an executive session by the committee unless it's been at least 24 hours after the public hearing has been held, unless it's the last week of session. Thank you, Mr. Chair.
Further discussion? Representative Engel. Got it right.
Thank you. Yes, Ingle. May I please inquire? Amendment sponsor. Thank you.
Aye.
Aye. I think it's a great amendment. This is something that I've heard commonly talked about from members in both sides and all sides of the majority party, that it's just best practice and good governance to have it on separate days, so conversations can be had. So people have the chance to follow up and look through things. So I want to thank you for offering it. Thank you.
Sure. Thank you.
Further discussion? Representative Meredith.
Thank you. To speak briefly in support.
Proceed.
Thank you. Simply say we talked about this in committee a little earlier. Strongly believe this is important because the whole point of public testimony is for us to be able to make changes to a bill based on that testimony. And if we go straight into an executive session or even do it moments later, we don't actually have time to draft amendments based on the testimony. And so I think this is good policy. The rule can always be waived if there's a situation that requires it to be waived. As the floor leader said, this should be the general rule. Well, then let's make it the general rule, and we can make exceptions when necessary. Thanks.
Further discussion? Seeing none. All those in favor of adopting House Committee Amendment number 4, please signify by saying aye. Aye. All those opposed say no. No. Noes appear to have it. New here, man. Any further amendments? Representative Meredith.
Thank you. Not surprisingly, I have a few, but I will try to go through them quickly. First, I have an amendment ending in .24H. Move for its adoption.
Representative Meredith has...
I believe mine are in a packet together that I passed out to everybody. All but a couple of them are in there. 24H.
Offered an amendment in 24H. And proceed.
Thank you.
I'll find it.
So this actually fits with one of the changes that the chair's amendment actually already did. But it goes to the conversation we keep having, that any bill or resolution that hasn't been referred to a committee by the speaker within 15 legislative days of being first read. I chose being first read because that means if it's filed at a weird time, that day that it basically goes on the record in session. 15 legislative days following, it'll be referred to a committee of the bill sponsor's choosing. This is, again, to prevent that situation where one person in the body has all of the authority to decide whether a bill ever gets to move to a committee. This does not require that a hearing be held. So this doesn't change anything on that front, and if the committee chairs still don't want to have a hearing on it, they don't have to. It simply decentralizes who the members have to lobby to get a hearing if the speaker hasn't already chosen themselves where it goes. And then, we can go harass a committee chair who maybe doesn't have 163 people to deal with and make our case to them that there ought to be a hearing. Just good democracy, simple change. Happy to take questions.
Discussion on amendment number 5. Seeing none. All right, all those in favor of adopting House Committee Amendment number 5 signify by saying aye.
Aye.
All those opposed say no. No. And the noes have it.
Mr. Chair.
Representative Meredith.
Thank you. I am going to keep going through these, although I can kind of tell what's happening here. But I think it's good to get these on the record. So I have an amendment ending in .23H, and I move for its adoption.
Representative Meredith has offered amendment ending in .23H. Proceed.
Thank you. So this is about remote testimony. I am concerned about the changes to remote testimony making it even more restrictive about when it can happen. I told you I'm also concerned about ADA problems and lawsuits and equal access and all of that. Without going into all of that again, this amendment would simply say that a committee shall allow for remote public testimony, that a request to testify remotely must be received by the chair 24 hours in advance of the hearing, and that the committee may impose reasonable restrictions on remote public testimony, which may include the length of time allowed for such testimony, the number of witnesses allowed to testify remotely, and any division of time among such proponents, et cetera. This still leaves a lot of room to decide how best to do it by a committee and to make limitations so it doesn't get completely out of hand. But it makes sure that we will always allow for it and provide a mechanism by which Missourians can, in fact, testify. Happy to take questions.
Discussion. Seeing none. All those in favor of adopting House Committee Amendment number 6, so signify by saying aye. Aye. All those opposed say no. No. And the noes have it. Failed to adopt number 6. Further amendments? Representative Meredith.
Thank you, Mr. Chair. I have an amendment ending in .25H, and I move for its adoption.
Representative Meredith has offered amendment ending in .25H. Procedure.
Thank you. So this amendment, again, conversations we had earlier already, makes it so upon the written request of any 5 members of the House, Committee on Rules shall conduct a hearing on any House bill in its possession. This is language that was actually taken out in the underlying bill from the current rules. And it puts that language back in for House committee bills. But it also adds that language for any bill, because as we talked about before, if there was not, in fact, a public hearing held on a bill, I think it's really important that the Committee on Rules have the chance, upon request of 5 members, to have a hearing so that we can have public testimony. It doesn't really change the Rules Committee. They still actually wouldn't even have the power to amend it. They'd have to send it back to committee if they wanted amendments. But it makes sure that the public has a chance to testify. Again, happy to take questions, sorry.
Discussion. Basically, you're putting back in what was supposedly or
That's the bottom half
offered
of
to
it.
take out as the bottom half.
That's
and
the
then-
bottom half.
and
The
then
top
you've
half
added
does
it in,
expand it, yeah.
And then you've added it in to the Committee on Rules because of the discussion we had earlier.
Correctly.
All right.
Yeah, thanks.
Making sure I'm writing this down. Further discussion? Seeing none. All those in favor of adopting House Committee Amendment number 7 signify by saying aye. All those opposed say no. No. And the noes have it. Further amendments, Representative Meredith.
Thank you. I have an amendment ending in .26H, and I move for its adoption.
Representative Meredith has offered an amendment ending in .26H. Proceed, sir.
Thank you. This, again, is one I talked about earlier, changing the balancing rule for budget amendments so that we are not bound by the total amount of dollars spent by the budget chair and are instead bound by the total amount of money authorized by the CRE, which means it's the House, the Senate, budget leadership, and the governor that have all decided on that number. This, again, to decentralize the amount of authority there, but also to prevent us in the House, as members of the House, being in a severely weaker position in amending the budget than members of the Senate. And I really think that's proven to be a problem for us. Happy to take questions.
Discussion. Just as a reference, because I'm only my third year, before COVID, would this have been an issue?
Yes, I probably would have still felt this way then, but it depends on who the budget chair is, honestly.
What?
Before 5 years ago, the budget chair in the House tended to present a bill that was based on the CRE and didn't set a whole bunch of money on the bottom line. That was a new development under the previous budget chair in my first year in office 6 years ago. That was the first time that we started to have this problem of the bottom of the budget chair's amendment being different than the CRE in the amount of money available to us to amend. That said, the balancing rule didn't even exist, I want to say 20 years ago. And it first existed, but the Budget Committee, it didn't apply to them. It was only for the House to try and limit the House. But the Budget Committee could still offer amendments to increase or decrease the total amount. So it still wasn't just one person. And then it was a budget chair, I want to say 10 years ago, that changed it to where all of the power got centralized in that one person. And since we're having a conversation about decentralizing power right now, I think it would be appropriate to go back to how we used to do things, at least partly, at least part of the way back. I still get being responsible within the CRE and appreciate that, but we shouldn't let one person by themselves limit all of the rest of us in deciding how to spend our money.
Thank you. Further discussion? Representative Hovis.
Inquire on that.
Proceed.
So I'm looking for some examples here, but with the amount that comes out of the CRE, did I get that correct? How much of a difference was that from what we had set in the House, which has the ability to set appropriations, because we're the ones that set the law for that?
Well, again, it's not the committee that set that.
No.
Yeah. The budget chair's version, and this actually comes from, I think, the initial bill filed, but some interpretations have been his sub even. This last year, there was about $1 billion difference, and a whole lot of that money got spent on the other side of the building. In previous years, I think the previous year was at its highest ever, and I want to say it was around $300 million. When it first came into play under now Auditor Fitzpatrick, I believe it was $100 million that he was setting on the bottom line, or in a reserve. Prior to that, this wouldn't have been an issue.
Right. Because our budgets were running so close to what revenues were, we didn't have that ability.
Yes.
Yeah, so I know from the House side of it, we are the ones that set that. I am concerned, and I need to study this more, but say if the governor or the auditor would come out and say the assessments are much higher than what we think they are, could those numbers be fudged by the CRE number? If the governor says we have an extra $5 billion, we say we have an extra $1 billion, I'm just using that example, then would that give us some problems knowing that we are the ones that
I think right now we'd still be limited by the budget chair's bill. The only way that would change under this rule is if they've actually updated the CRE, which again requires agreement of the three branches, if you will. Both legislative branches and the governor agree on updating it. Then that could change what we're able to work with, which honestly is a nice point, because in a situation like now where our predictions are kind of struggling a little bit, rather than forcing the budget chair to go file a brand new appropriations bill with a different bottom line, this would allow us to adjust on the floor if our estimates have changed dramatically in that time.
I personally think by the time COVID money is spent, this is not going to be an issue because we'll be back to only being able to afford what we are bringing in. But
might be right, but again, before COVID, this started before COVID with the money set aside on the bottom line and the budget chair essentially single-handedly deciding we're going to have $100 million bottom line. And that was not done before. And the Senate was able to say, nah, we disagree, we're going to spend some of that. But the House was not able to, as individuals, we're not able to offer doing that.
But my understanding is even if the budget chair would do that and this comes to the floor for us to vote on, we have the ability to change that on the floor ourselves.
We do not.
We do not? I thought
No.
we could do amendments to those whenever they come to the floor.
That's what the balancing rule that I'm amending says. It says that for any increase, you have to have a corresponding equal decrease.
But that means you have to file a bill to decrease spending somewhere else to be able to do that.
An amendment, yes. But that doesn't allow you to take that decrease from the bottom line and change the overall amount of money spent. That's what's currently prohibited by the balancing rule.
Thank you, Mr. Chairman.
That timing you discussed there seems to go into like an additional cost a state had around that time. And were they preemptively doing that on purpose based upon possible expansion of things? Was that, I mean, I wasn't here, I'm just asking.
You mean like Medicaid expansion?
Yeah.
No, it was before that.
It was?
Yeah, it was before
But that wasn't even in the works?
No, it was just and honestly,
I'm just asking, yeah.
a pretty reasonable decision, I thought, by the budget chair at the time of, let's set $100 million aside for just us being wrong about our estimates. And it gave room for that to be in the supplemental and things like that as well.
Understood.
But it wasn't, I don't think, about that.
Okay, just curious.
You'd have to ask
A lot
him yourself
of movement.
that.
Yeah, understood. Okay.
I'm pretty sure he was committed to the idea that expansion was not going to happen. So.
Further discussion? Seeing none. All those in favor of adopting House Committee Amendment number 8 signify by saying aye. Aye. All those opposed say no. No. And the noes have it. Further amendments, Representative Meredith.
A few more, thank you. Point 19H, I think that was my wonkiest one that would require discussion, so we should be faster since that one. But another budget amendment ending in point 19H, move for its adoption.
Representative Meredith has offered amendment ending in point 19H. Proceed, sir.
So this would simply allow members other than the budget chair to also file appropriations bill. It would be the budget chair and the ranking minority member of budget, and then any other member of the House may also file appropriations bill with leave of the speaker. So again, this is about decentralizing the power from one person to file and originate budget bills. A spending bill. 19H.
Discussion. Representative Wyndham.
To inquire of Representative Meredith.
Proceed.
Thank you. So this only says it gives you authority to file bills. It doesn't necessarily say that the bill will be heard or that it will.
Yeah, just like any other bill we file. But, from a minority caucus perspective, as we talked about, our ability to file bills is a way to put on the record what we stand for. And without the ability to file bills, it's hard to do that in any official way. And this would allow us to present alternative options. But it also would just allow any member to file a single spending bill if the speaker grants them the authority to do it. So it doesn't have to be the budget chair every time.
Do you think that could possibly ease the way for negotiations if you're able, as the ranking member, let's just say you are the ranking member on budget in this upcoming session, do you think that makes it easier for you to negotiate with the budget chair and other members if you already have your thoughts all lined out in one place?
Oh, I think that's possible, to be able to show them here's what we stand for. They can look at it even before we talk in a really helpful way. Honestly, I also think it might decrease the ability of the budget chair to essentially block anything they don't like single-handedly and hold the entire budget hostage. I'm not suggesting the current budget chair would do that, but a budget chair that is unhappy with the budget as it comes back from the Senate, as we've all wanted to vote for it, if he's the only one that can file an appropriations bill, he can simply say no to his bill. And allowing another member to file an appropriations bill would actually allow the speaker to go around that if that one person is blocking our budget from getting done.
Okay, thank you. Thank you, Mr. Chair.
Further discussion? Seeing none. All those in favor of adopting House Committee Amendment number 9 signify by saying aye.
Aye.
All those opposed say no. No. And the noes have it. Representative Meredith.
Thank you. You'll be glad to know I'm skipping a couple that I believe have already been offered.
Quite all right.
I have one ending in .37H, and I move for its adoption.
Representative Meredith has offered amendment ending in .37H. Proceed, sir.
Thank you. So this, I think, is just a 21st century update. Members may attend a committee remotely when called for by 2/3 of the appointed members of the committee during a state of emergency as declared by the governor, or for any reason when called for unanimously by the committee. So it's actually allowing us to do what the rest of the world is doing now, in that you can attend a committee remotely, or the entire committee could be held remotely if there is a state of emergency and 2/3 of the members of committee approve of doing so. Any one member could do it as well, or all of the committee could do it as well for any reason, if the entire committee agrees unanimously to do it. Right now, I don't believe we have a way in our rules to have a virtual committee hearing, or even to allow a member facing a dire situation to attend committee. That might be very important to them and their constituents if they can't be in person. Again, everyone else in our economy is adjusting to this. I think that we ought to too. I'm happy to take questions, sorry.
Discussion. I do. So you're saying to put this just as a standing rule for every committee, or you're saying each committee can decide if they want to do this?
Yes, so the committee can decide if they want to do this, and it only takes a 2/3 vote to do it if there's a state of emergency declared by the governor.
Okay.
If there's no state of emergency and they just want to do it for a different reason, then they have to unanimously decide, yes, we're going to meet virtually today, or not today, next week.
Yeah, wouldn't they have to do that ahead of time?
Well, it'd be the same notice requirements of committee hearings generally, which is at least 24 hours.
But if it was a state of emergency and they weren't at the Capitol, how could they vote?
Well, they might have to do a vote in person first to allow for
order to do
virtual.
this.
Yeah, but that's at least gives them the option of having a subsequent hearing. Like
I
during
understand. Yeah,
COVID, for example, we all met a couple of times.
I'm sure.
And then we were like, well, now we really can't anymore.
Yeah.
And other kinds of emergencies might actually be more problematic in that way.
Well,
but if we're able to come in to at least say we're going to allow for the next couple of weeks our committee to do its hearings remotely, and we're all going to vote for that, I think that would be a good thing.
No, I think I understand. I was just trying to be, if there's a state of emergency, normally it's not a COVID-like event.
Right,
It's
right.
like, okay, everybody can't get anywhere. I-70's gone. So how are we going to? I'm just trying to. How do you get through?
A good
this?
question.
If you don't do it ahead of time and present, and if you leave it to each individual committee, and some committee decides, I ain't doing that, and then
Well, I could see us,
you'll-
for example, if we know a snowstorm is coming next week,
okay.
and we think that we're likely to all be stuck at home, but we don't want to cancel the hearing, we could go ahead and say we're going to do the hearing remotely and vote on it, then go home for the weekend, and if the blizzard happens, we don't come in person.
I see what you're saying.
It's better than we have now. I'd go further, yeah, probably, but
Understood. Further discussion? Okay. Oh, sorry, Brenda. Sorry. Representative Wyndham, go ahead.
Thank you, Mr. Chair. I'll keep it brief. I'll just say I think that this is a good amendment. It could, I think, go further or be more finely tuned so that if there was a state of emergency, that it'd be a little bit easier to avail ourselves of this, if you will. So maybe being after it's a state of emergency being called by the speaker, and then we wouldn't have to meet together to take that vote. Because I mean, I don't foresee this being used. Nobody ever foresees an emergency coming, right? But I don't foresee this being used. But I think it's something good to have in our back pocket because, I mean, even it just says attend a committee hearing. I would say that we may need to vote on something. If it's an emergency, I would hope that we're voting on something. That's all I have. Thank you, Mr. Chair.
Thank you. Yeah, I'd hope that it couldn't be abused, but that's for, more legal line in minds to figure out. Sir?
To comment one more?
Please.
Thank you, sorry. Also in response to your question, if we're just voting to allow one or two members to attend remotely, I think that would also allow us to do that with the rest of the committee present in person, but two members maybe home dealing with a tornado that hit their community, but we don't want to tell them they don't get to attend committee today. And so they're able to attend remotely, and we would vote to allow that.
Understood.
Thank you.
Further discussion? Seeing none. All those in favor of adopting House Committee Amendment number 10 signify by saying aye. Aye. All opposed say no. No. And the noes have it. Further amendments. Representative Meredith.
Thank you, Mr. Chair. I actually thought we were about to get some agreement on that one, but perhaps on the floor.
Yeah, there's other opportunities.
Honestly, that's one of the reasons I intend to continue with this, even though I can tell the decisions have sort of been made. I'd like them to be on the record so you all have a heads up, and so others have a heads up as these are offered later.
I believe, yeah.
Thank
More
you.
discussion's probably better.
Mr. Chair, I would say on all these you had, I see some things that I could actually see that would be good. But we as a body can waive those rules anytime there's a severe emergency, and we can make that still happen and work. And I think that if we get a committee that all 10 of them decides they don't want to meet and they all vote as unanimously to go and just, it may take away from our people that want to come here and talk.
The idea of, because how do you do, public testimony and things of that nature.
Exactly.
So,
And
but
if it's truly an emergency or we need to set something aside for a member, I think we have the ability to do that already.
that's a good point.
Thank you.
But anyway.
Thank you.
Proceed.
I appreciate that point. And I will say, the trouble is I don't think we have done that before, and I think putting it in the rules as an option makes it clearer that that is something we can do and ought to occasionally do. And perhaps the reason we haven't is because it's not in the rules. Okay, so just a couple more, I promise. I have an amendment ending in .18H, and I move for its adoption.
Representative Meredith has offered amendment ending in .18H. Proceed.
Thank you. So this one is, I'll admit, inspired a little bit by a friend of ours on the other side of the building. And I think it's of his proposals to our rules, more moderate, but good idea. This is simply that if more than a third of the members of the House co-sponsor a bill, that bill shall be referred to a committee immediately by the Speaker and given a public hearing within 15 legislative days of the referral. Again, gives a little bit of time. But if a third of our chamber, and again, just to be clear, the Democrats alone can't do that in our current legislature, it would at least get a hearing.
Discussion. Referred to any committee?
I'm sorry?
Referred to any committee, though?
It's up to the Speaker, just like every other
Anything else?
referral.
Yeah, go ahead.
Where would
Still
it come
thinking.
up with the 1/3? Why is it not 50% or 75% or something like that?
It's sort of like the reverse of a supermajority, where it's a third, doesn't have to be a majority so that it has the will of the whole body, but it's a large enough share to warrant a public hearing. Not even an up and down vote, not even passing, but ought to get a hearing if a third of the members are willing to co-sponsor it.
No,
But they're all
I would
reasonable.
say from my perspective that if it was a higher number, it could be considered, but at the end game there, even if it gets a hearing, doesn't mean it's still going to be, it's going to make it to the general floor for debate.
No, but it allows the public to testify on the issue, which might be better than organizing a rally out on the steps.
Good.
I would be opposed to the third. I would think that if over half the body would be approval of that, then that's something we could talk about. I don't want to gum up the system because we have very limited time slots to get legislation to the floor. Having a hearing may take that away if we have a minority of a third that says they want hearings on all the bills that they filed. And that could be either side if the Republicans were in a minority. But I would be opposed to this particular amendment.
I'll also say one reason that I chose a third over 25% as an example is because the minority caucus is under a third.
Today.
And yeah, well, if it changes in 2 years, the rules change in 2 years too.
In theory. We're working on it. Representative Engel.
To inquire the amendment sponsor.
Prissy.
Of the bills that we passed that were TAFP'd last session, how many lacked co-sponsors? Do you know?
I don't have the exact number, but I'm going to guess it would be in single digits that had this many co-sponsors.
Well, I'm wondering how many bills that we TAFP'd that had no co-sponsors, because I'm sure that there were some.
Oh, I'm certain.
And that lacked the support of, at least the co-sponsorship of
That enthusiastic
members.
level of support.
Right. Thank you.
Further discussion? Seeing none. Okay. All those in favor of adopting House Committee Amendment number 11 signify by saying aye.
Aye.
All those opposed say no. No. And the noes have it. Representative Meredith, proceed, sir.
Thank you, Mr. Chair. I have an amendment ending in .20H, and I move for its adoption.
Representative Meredith has offered amendment ending in .20H. Proceed.
This is another amendment that just takes us back to how our rules used to be, not that long ago. And it simply allows what we call casually amendments on the fly. Right now, we are allowed to do amendments on the fly if there are amendments to the amendment, but we're not allowed to do that for amendments. And it means, again, with one person or two people being able to call up a bill, they can prevent further amendments from being offered. And then we have to go about it, as we've already talked about, in roundabout ways like amendments to amendments, instead of a much more straightforward path of, hey, we're on the floor talking about a bill. While we're on the floor talking about a bill, a new problem is identified, and we go, oh, we should fix it. And then we realize, oh, there aren't any amendments filed for us to amend. And it's a very strange system we have where we have to find an amendment that might get called up just to be amended to do something else, when we could have just offered an amendment, filed an amendment based on what was being talked about. It just overcomplicates our process. And prevents full vetting and discussion. So this would just go back to how it used to be. Happy to take discussion.
Discussion. When you say how it used to be, like, when was that?
I was afraid of that question. I don't know how many years ago.
But
I don't think it was that long. Maybe 15-ish. It was while that gentleman was here in the building, and he's been here for what, 20 years? Mark, 20 years you've been here? 24, and it was while he was here, so it's not the distant past.
Understood.
And it's allowed in the Senate. Again, that's something the Senate can do that we can't.
And
Representative Hovis. Yep.
yes, thank you, Mr. Chairman. What was that change made? Do we know why that change was made? That's I always like to know why we
Honestly,
do things.
like most of these changes have been made to concentrate power in the hands of a couple of people and make it harder for members to do things that our constituents want us to do. I'm not saying that just to because it's a nice, that's the truth.
For the day.
And it's true of a lot of our rules that I'm not even touching in here.
How long was that rule in place prior to it being changed 15 years ago? Oh, that's all right. Has it always
Was that always the rule?
Was that rule always in place until 15 years ago?
It's not a public hearing. Thank you. Yeah, my understanding is that that it was always the rule until this was added. Sort of like was presented by some public testimony earlier. Over the course of time, our rules have gotten a lot longer and a lot more complicated. And I believe this is one of those things that was just added to add another tool for a couple of folks to control things.
Okay. Possibly, but I don't know enough to know. Further discussion? Representative Evans?
Sure, to comment on that.
Proceed.
This, I've tried to be kind of quiet today, but to say that unvetted bills that are filed, amendments that are filed on the fly, without going through committee, without hearing, without the opportunity really to read the amendment in advance is a good thing. I just have to respectfully disagree. And I think it's true across the state of Missouri that the vast majority of people criticize us because at the end of the year, we seemingly always file these omnibus bills, or we turn to these omnibus bills that have no such vetting, that have no such public comment, that we have little idea, because there's so many of them, what they actually say. And to promote that as the way of doing business is not catering to leadership. That's just common sense, business sense, practical sense, that you want to pass a bill that you know what it says, that you've had time to think about, you've had time to talk to your constituents about. I know lobbyists like bills on the fly, and they promote that sort of thing, but good government, I do not believe, does. I know we're getting a lot of comments from lobbyists. On one hand, we heard this afternoon that omnibus bills are not good, but from others, we say we should allow more of them. But certainly, I think the general public criticizes most because we don't think enough about what we do.
Further discussion? Representative Meredith?
To respond briefly.
Proceed.
Simply would say that we already can do all of that. That's how amendments to amendments work. That's what's already happening. We already have a gazillion amendments filed on a bill that create a Christmas tree omnibus bill. If we want to address that problem, this is not the rule issue to do it. This actually simplifies what's already happening by making it happen as amendments instead of as amendments to amendments, which gets convoluted. So it would make it a little bit easier for folks at home to follow what's happening.
Since he had a comment, if I could
By all
respond to
means,
that.
yes, sir.
Sure, it simply takes out the requirement that you have to do it in advance. You have to give us, the people that vote on this stuff, some advance notice of what you're going to file. In the grand scheme of things, that may sound good, but we have no ability, if you file all these bills, we attempted earlier to limit the amount of fly-by-night bills, and that was compromised out earlier. So to say we're not trying to do that, we are trying to limit omnibus bills and Christmas tree bills and bills that the public think we do a bad job of, and we need to be more critical in our review of bills. You can't have both. You can't say we don't spend enough time on bills. Oh, you spend too much time on bills. This would make us spend even less time on bills, and to me, that's just never going to be a good thing.
Further discussion? Seeing none. All those in favor of adopting House Committee Amendment Number 12 signify by saying aye. All those opposed say no. No. And the noes have it. Representative Meredith.
Before I offer my last one, I did want to point out I had one about the time limit change that will likely still come up on Wednesday. But because the time limit was reverted to the 15 minutes, this would actually be previously amended material. But the other pieces of it that I think we ought to be still addressing are clarifying that that's 15 minutes per bill, underlying amendment to the amendment, et cetera, which, as the drafters told me immediately when I made the request, they believe that to already be the rule. But it is not how the rule was enforced last year. And so I would like us to clarify, just one time, I would like us to clarify that in the rules because it has been interpreted in a different way. Secondly, I do still think we should add the ability, even at 15 minutes, to yield time. I think that's a really productive improvement to our rules. So I hope that that gets brought up on the floor.
Okay, just to make sure I'm just taking notes here.
Sure.
15. So you're saying, and you said the drafter said that it should be 15 minutes per each, not per
And they
speaker.
believe that already is
That's
what it
all
says,
should
and
be.
I agree with them.
And you're saying it's just not in practice, but
Yes, it has been
for
enforced
sure.
differently, and I think we ought to clarify that.
Okay.
And then lastly, I have an amendment. Yes, last one. Ending in .35H, and I move for its adoption.
Representative Meredith has offered amendment ending in .35H. Proceed.
Thank you. So this one, again, I brought up earlier in conversation with the bill sponsor, floor leader. It is a modification to the previous question motion that says that it shall only be in order so long as the body has spent at least 1 hour on debate of the measure, and the members of the majority caucus and the minority caucus whose members are seeking recognition, so if they have somebody still wanting to talk, have been allowed at least 30 minutes total per caucus of discussion of the question. Except that the limitation may be waived by a vote of 2/3 of the electeds. So if we don't have time at all, 2/3 can still say, no, we're doing the PQ as we do it now. And the time limit shall not be applicable during the last week of regular session. So I'm trying to be as moderate with this change as I can, while I would go a lot further. It makes sure that the minority view of a bill is at least allowed 30 minutes if they're trying to have it, to talk about their opposition to that bill before that bill is voted on. I think that our constituents deserve at least us spending 30 minutes about the bill, if members are still standing. If they're not, then it's not an issue. And a full hour of debate. Yeah, I think it explains itself, but I'm happy to take questions.
Discussion. Representative Hovis, go ahead.
Yeah, just a comment, I respect the gentleman's thought process on that. I know one of the things when we were trying to cut time by how long someone could speak, which we, I think, have given back now, it was to try to speed up what we were doing. If we're going to now arbitrarily place that there's always going to be at least 1 hour of debate on a bill that may be contentious, I'm not going to be opposed to that, but when the question is called, we still as a body have the right to vote yes or up or down if we want to still hear more debate, and we have the ability to stop it or keep it going at that time. And I don't know that, because, again, rules can always be waived. We voted on it many times last year if we think that's important to do. But I don't think this amendment is necessary for that at the moment.
Further discussion, Representative Wyndham.
Thank you, Mr. Chair. I'd like to inquire of Representative Hovis briefly.
You yield, Representative Hovis.
Oh, yes, I do.
Proceed.
So to make it an actual inquiry, I'll start with the question.
Yes.
Do you recall a time at which a motion...
Representative Wyndham, I can't hear you. Barely.
Okay. Thank you, Mr. Chair. Representative Hovis, do you recall a time at which a previous question motion made by the majority floor leader has been not sustained?
I cannot remember one, but I'm not saying that there was.
Okay. I don't recall one either in our 4 years here. So I think that the difference in putting it in the rules as opposed to saying, well, we can override someone that the majority caucus has voted for, it sounds a lot better technically than it does in practice. It's not going to happen. Even if it starts off where, oh, they may be voting against the floor leader, votes flip. So to say before a session even starts that we want robust conversation on these contentious issues is different from saying, oh, well, if it's that contentious, we can just override the vote of the floor leader or the motion of the floor leader. Not going to happen. I mean, let's just be real.
No,
It's not gonna happen.
it's highly unlikely, and I would tell you that that's why we vote on that. I just look back in history. I talked to a gentleman that used to be here before the Republicans were the majority, and the speaker at the time would never call on a Republican, even if they were jumping up and down in their chair, waving a white piece of paper to speak. That was just the way things were done at that time. But what I would say is sometimes I've seen, and I've been happy when the question's been called, because sometimes we know that a bill's going to be voted on. A lot of times we have an idea of how it's going to be voted out by the way the things go. But a lot of times people will just be redundant to kill time by continuing to repeat the same arguments. And once I've heard them one, they don't carry as much weight the second time. And I'm not saying it happens every time, but I know sometimes people are just wanting to get their speaking points out when really that bill could be moved forward.
I get it, and I'm not trying to be. I can't think of a good term for it, so I'll just say argumentative with the majority caucus. However, it's not up to a couple members of the majority caucus. I see folks, throwing their hands up in the air and holding up pieces of paper to say PQ. It's not up to a couple members of the majority caucus or even the minority caucus for that matter. We represent 37,000 folks apiece. It's some folks in this body that represent more folks than the speaker, I'm pretty sure, because we don't all get that exact 37,000. But to say that someone that has sat down all year and has waited for this one issue to come up, that they can't speak because we got tired of someone speaking on every issue, I just don't think that's fair. And life's not fair. No. But rules should be when we're setting out to do them before a session starts.
Well, I know what we've seen in the past, but I feel very comfortable with current leadership that they're always going to give the minority party. I know there's times you guys get to speak probably more on some bills than what we do because we just don't have a reason to stand up maybe sometimes. But I don't think that it's unfair the way that we've been doing it. But I'm also respectful of making sure that you guys get your time on the floor, which was unlike 30, 40 years ago. So, I mean, we just want to make sure that everybody gets their time.
Further, Representative Engel.
Thank you, Mr. Chair. To briefly inquire of Representative Hovis.
Proceed.
Sorry, this is awkward. I feel like the crux of a lot of this committee hearing has been about trying to speed up the process. And I think that it comes down to a fundamental disagreement between the people on this committee with how government should be run. And I think that's the crux of it, because when I hear that everybody's trying to speed up the process, I think, no, why should we do that? Especially if it's a contentious bill, especially then. And I have sat through many redundant debates. I have heard about feral hogs more than anyone I know outside of this body. And I know that you all have too. And so, but those are important issues to different members. And something that may be really important to me may not be important to you at all, and vice versa. But we're all in this together. We're all in this to represent, our 37,000 people, but it impacts the entire state of Missouri. And so while something may not be important to you, and you may be tired, frustrated, et cetera, there's a reason why we gum up the works. There's a reason why, because it should be really hard to pass bills. It should
I agree
be.
with that.
And part of that is the robust debate process. And you may not get to the crux of the issue until you're debating it. And it's those few people watching at home that may pick up part of that debate, and it may spark another issue. And so I think it's we do a disservice when we try to limit debate, even if yes, we've all sat through very, very long soliloquies and inquiries that were redundant. But it wasn't redundant to that person speaking. And I know that everyone on this committee would be very offended if that kind of thought was directed at them and something that they felt was really important, and someone held up a PQ sign. And so I think it's really important that we be respectful of our colleagues and what they think is important, regardless of whether we do, because they were elected by 37,000 people as well.
No, I would agree with you. I would like to see movement on a lot of our bills much sooner in session so that we are not piling
What
them
does
up at the
movement on
end of
bills
session.
look like?
Well, it's a good question.
Thank you, Representative.
Yeah. So making sure that we are making our work so it's more spread out. But as you well know, lots of rules can be manipulated, whether it's one side or the other. That's always been a case here. Even if we get towards the end of the session and we've got a lot of bills that we're going to try to get to the floor, knowing that they've not been able to make it to the floor until the last moments, sometimes if the other side doesn't want us to get to other bills, you just come up the system by talking more. And that plays both ways, depending on what's doing stuff. And it's just it's a strategy sometimes, but I think that if we've got a bill that has been going on for a while, and I've been on the floor, you've been on the floor, and probably have had bills that may not be as important, because I don't think any bill's not important, but there may be something you have a greater interest in with your background, one that I may have in my background, and I pay probably as much attention to all, but I want to have some comment on those. But once I've heard that comment, if there's more people that continues to say it, then it gets redundant. And that's one of the things that I just think that if we're going to guarantee a certain amount of time, especially on a bill where that time is not necessary, then it's just going to keep us away from getting to other bills. That's my point. That's why when we call the question, we have the right to vote, whether to continue that debate or go on with the vote.
Representative Meredith.
Thank you. Just to respond briefly.
Proceed.
Again, this isn't applicable in the last week when things are in a hurry. This also may be waived by a vote of 2/3 of the members. So the members would have the right to vote still, even if there's only been 5 minutes of debate. If 2/3 vote for it, it would be a PQ like now. If you're saying an hour of debate on the only bill we hear next week is gumming up the system and slowing it down, and our constituents don't deserve 30 minutes of each side or an hour total of debate, I don't think that's what you mean. And excuse me, the fact is we have experienced many times zero debate at all. Early in session, when there's nowhere else that we have to be, because a floor leader, again, not this one, because he hasn't been there in that job before, has been mad at somebody for something that happened in a different bill completely, or because there are other things they want to go do that evening. I don't think that's right for our constituents. And so if all we're saying is, guys, we can at least afford an hour, and you talk about redundant testimony, and yeah, there might be redundant testimony. Okay, 30 minutes of redundant testimony? Again, a lot of us, the only powers we have are a few in this building. And one of them is to speak. One of them is to be a voice for our constituents. And if it's been acknowledged by leadership that we already know what the outcome of a bill is going to be, okay, maybe we do. Maybe we all know. But we're still here to represent the voices of the constituents that sent us here. And that opportunity on the floor is that chance to speak for them. If we don't do it then because everything was agreed upon behind closed doors and we already know what the outcome is, that is not what our constituents sent us here for, and we are denying them the role that we're supposed to play for them. So this one means a lot to me because there's not much I have here other than my voice. And there's not much my constituents get from what we do here other than saying, thank you for speaking for me. And all I'm asking is a slight limitation on the previous question motion that used to be used less than 10 times a year and is now used over 100. Limiting that a little bit, is that so much to ask for? So that's all I'm asking.
No, and Representative, you made good points. I mean, some of the things you made earlier by saying if someone's doing it because of they're agitated with someone or they're angry, they should never be doing that. We all know that happens. It's about relationships up here sometimes, not only with the people we work with, but also with the people that we represent.
Yeah, and yet to Representative Wyndham's point, voting against the floor leader on that vote has consequences because of the concentration of power in a couple of people. And because that concentration of power, I have Republicans come to me all the time and say, oh yeah, I didn't want to vote for that, but I can't. I can't vote against the speaker. Well, or I can't vote against the floor leader. Well, okay, then let's put a rule in place that makes you not have to.
Well, that's occurred on both sides of the aisle. I mean, there's been people removed from committees on your side of the aisle because they didn't vote the right way. We'll talk about that in the future. Thank you.
Receipts needed.
Further discussion? Seeing none. All those in favor of adopting House Committee Amendment number 13 signify by saying aye. All those opposed say no. No. And the noes have it. Anything further amendments this evening? Seeing none. Let me check my notes. All right, so I move the amendment. That's in there, right? Okay, I now move that we roll the amendment into a new substitute and adopt the substitute. All those in favor signify by saying aye. Aye. All those opposed say no. And the ayes have it. We have adopted the substitute. I now move that the House Committee substitute for House Resolution number 11 be voted do pass. Any discussion? Representative Wyndham.
Thank you, Mr. Chair. I'll just briefly say that I plan on voting no. I do appreciate the changes that have been made from the original bill that we had here. However, I feel like it was just a matter of throwing out one of the most extreme things that we could and then watering it down to what we had last year and saying, oh, that should be good enough. So my final statement before the vote would be that we work for the people of Missouri, not the leadership of the Missouri House. Thank you, Mr. Chair.
Further discussion, Representative Meredith?
Just to echo those sentiments and say, first of all, thank you for allowing the robust discussion on this all today and allowing us to get all of these things on the record. I will still be a no vote, though I think that the committee sub is an improvement on what we had. But I think we need to go a lot further, especially with the underlying bills that already existed. And while there is a particular level of attention happening right now on House rules and concentration of power from both sides of the aisle, I think that it's a good time for us to revisit some of those things in our own rules, take the plank out of our own eye, so to speak. Before we criticize what's happening on the national level, we should maybe look at what we're doing here that's kind of the same problems and address them. And I don't think we do that here. So I'll be a no. Thank you.
Further discussion? Seeing none, please call the roll.
Chair Pouchet.
Aye.
Representatives Hovis. Aye. Meredith. No. Buckheit Courtway. Aye. Evans.
Aye.
Faulkner.
Aye.
Engel. No. Owen.
Aye.
Thompson.
Aye.
Wyndham.
No.
By a vote of 7 aye and 3 no, you have passed House Committee substitute for House Resolution number 11. Oh, I'm sorry. I substitute do pass, so sorry. So you have voted do pass. Seeing no further business in front of the committee, thank you all for coming and sticking around. We can adjourn.